we have the assisted listening device for the juror? We need.
Today, jury deliberations are expected to begin in the murder trial of Jacksonville rapper Hakeem Robinson, also known as Ksoo. He and Leroy Whitaker are both accused in the 2020 murder of Charles McCormick. First, we're expecting more closing arguments from Robinson's counsel. Then the case will be in the jury's hands.
All right, thank you, and good morning, ladies and gentlemen. Welcome back to Courtroom 407. I do want to ask if during this overnight recess, leaving yesterday or arriving today, if anyone attempted to speak to you or say anything to you about this case or approach you in any way about this case. If so, please raise your hand. Okay, and for the record, I see no hands raised. Did anyone see, watch, listen to anything on television, newspaper, radio, or social media about this case? If so, please raise your hand. All right, thank you, ladies and gentlemen. So now both the state and the defense have rested their cases, and the attorneys have presented their final arguments to you. So I am now going to, I need for you to listen carefully to the instructions that I am about to give you, which I remind you, you are required to follow. For your convenience, the jury instructions are going to appear on the monitors before you, so you can easily follow along as I read them to you. And I will send in one hard copy of the instructions for your use during deliberations while you are in the jury room. So let's please be sure that the monitors are on and working. Yes? All right, very good. Let us begin. Members of the jury, let's see. I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Leroy Whitaker Jr. has been accused of the crimes of murder in the first degree and burglary with an assault or battery. In this case, Leroy Whitaker Jr. has been accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. I now instruct you on the circumstances that must be proved before Leroy Whitaker Jr. may be found guilty of murder in the first degree or any lesser included crime. As to count one, to prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Charles McCormick Jr. is dead. Number two, the death was caused by the criminal act of Leroy Whitaker Jr. or a principal. Number three, there was a premeditated killing of Charles McCormick Jr. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. As to count one, to prove the lesser included crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Charles McCormick Jr. is dead. Number two, the death was caused by the criminal act of Leroy Whitaker Jr. or a principal. Number 3, there was an unlawful killing of Charles McCormick Jr. by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and, number 2, is done from ill will, hatred, spite, or an evil intent, and, number 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. As to count 1, to prove the lesser-included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Charles McCormick Jr. is dead. Number 2, Leroy Whitaker Jr. or a principal intentionally committed an act or acts that caused the death of Charles McCormick Jr. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. As to count 2, to prove the crime of burglary, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Leroy Whitaker Jr. entered a dwelling owned by or in the possession of Barbara Buckley. Number 2, at the time of entering the dwelling, Leroy Whitaker Jr. had the intent to commit an offense other than burglary or trespass in that dwelling. You may infer that Leroy Whitaker Jr. had the intent to commit a crime inside a dwelling if the entering of the dwelling was done stealthily and without the consent of the owner or occupant. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. If you find Leroy Whitaker Jr. guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing the burglary, Leroy Whitaker Jr. assaulted any person or battered any person. An assault is an intentional and unlawful threat, either by word or act, to do violence to another, at a time when the defendant appeared to have the ability to carry out the threat, and his act created a well-founded fear in the other person that violence was about to take place. A battery is an actual and intentional touching or striking of another person against that person's will, or the intentional causing of bodily harm to another person. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, number 1, the defendant intended the crime to occur, and number 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. For first-degree premeditated murder, the state must prove the defendant intended that the killing of Charles McCormick Jr. to occur. It is not necessary for a principal to know every detail of how the murder in the first degree or any lesser included offense, as the evidence supports, will be committed as long as the principal intended the murder in the first degree or any lesser included offense, as the evidence supports, to occur? And did some act or said something that was intended to help and did help the first-degree murder to occur, or any lesser included offense as the evidence supports? The state must prove that the crimes were committed on January 15, 2020. It must be proved only to a reasonable certainty that the alleged crimes were committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Number six, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number seven, has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number eight, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Number nine, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, or has been promised immunity from prosecution, or hopes to gain more favorable treatment in his or her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation. Not necessary to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. Do this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number three, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number five, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Number eight, your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, during this trial, I have permitted you to take notes, and you will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid your individual memory. You should not compare your notes with those of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they're as follows. I am holding in my hand a one-page document styled State of Florida versus Leroy Whitaker, and it's titled Verdict Count 1. And there are 4 verdict options for your consideration. The first one reads, "We, the jury, find the defendant guilty of first-degree murder as charged in the indictment." If that is your unanimous verdict, you mark that line with an X or a check. The second verdict option reads, "We, the jury, find the defendant guilty of second-degree murder, a lesser included offense." If that is your unanimous verdict, you mark that line. The third option reads, "We, the jury, find the defendant guilty of manslaughter, a lesser included offense." And if that is your unanimous verdict, you would mark that line. And then, "We, the jury, find the defendant not guilty." If that is your unanimous verdict, you would mark that line. So say we all, done at Jacksonville, Duval County, Florida, and there's a line for the foreperson to sign and date the verdict form. Similarly, there is a verdict for count 2, and you have 2 verdict options, and they read, "We, the jury, find the defendant guilty of burglary as charged in the indictment." If that's your unanimous verdict, you mark that line with an X or a check. And if that is your verdict, then you have to make one of the following 2 sub-findings, or rather select one of the 2 that are underneath that option. And those additional sub-findings are as follows. "We, the jury, find the defendant committed an assault or a battery during the course of the burglary." Or the second option is, "We, the jury, further find that the defendant did not commit an assault or battery during the course of the burglary." So again, after a unanimous decision on that finding, you would mark the appropriate line with an X or a check. The second verdict option as to count 2 reads, "We, the jury, find the defendant not guilty." And if that is your unanimous verdict, you would mark that line. So say we all, done at Jacksonville, Duval County, Florida, and again, a line for the foreperson to sign and date the verdict form. Now, a separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms and to bring those verdict forms, let me back up, to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. And these communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, you can send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the vote in the note. If you have questions, I will speak with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, either in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law, and no juror has the right to violate the rules we all share. So that will conclude the jury instructions, ladies and gentlemen. Like I said, I will send in one hard copy of these instructions with you. I have the 2 verdict forms here with you. You may take your notes with you. And all of you will now be excused to deliberate your verdict with the exception of juror number 15. I don't want to say your name, sir, but I don't know if you were aware, you were the alternate in this case. We generally don't share that information with our jurors, but that means you won't be excused to deliberate with the rest of the panel. However, do you have any personal items in the jury room that you need to retrieve before you are excused to go? All right, I'm going to ask the rest of the jurors to remain seated. If you will go quickly with the bailiff to retrieve that item and then come right back here as matters of instructions for this jury. The bailiff will show you when you go back to your jury room, there is a buzzer that you would normally ring if you have a question for the court or if you have a verdict. And that's the buzzer that you would normally press. However, once I excuse you to deliberate, we here are going to be doing the closing arguments for Mr. Hakeem Robinson's case. So what I ask is that you not use the buzzer. It's rather loud and distracting here. But instead, we're going to have a bailiff seated outside of your courtroom, and you can simply knock on the door and let him know if you have a question or a verdict. Likewise, if it's a question or a verdict, I would ask that you be patient with us, because if we're in the middle of closing arguments or in the middle of my instructions to Mr. Robinson's jury, we don't want to interrupt those. So I respectfully ask that you continue being patient, as I know you have been, so that we can take an appropriate break at the appropriate time, and then I can answer your question or receive your verdict. Lastly, there are several exhibits, of course, and we're going to send the vast majority of them with you now. What we can't send in now are some of the physical objects, which can't be duplicated. You have your own copy of these binders and the photos and the documentary evidence. You will be able to take that. However, some of the physical objects are going to be used during Mr. Robinson's closing argument. And of course, once they go out to deliberate, the 2 juries are going to have to share looking at those items. So we will swap them back and forth. But if there's any particular item that you wish to view, if you will put that in a note, knock on the door, give it to the bailiff, and he'll notify us, and we will send it in to you for your review just as soon as we can. And to make things a little easier, there is an index or a list of the various items that have been moved into evidence, so you can identify it by its number. And then we will be sure to send it back to you as soon as we can. One rule I have for all my trials, however, is I do not allow firearms and live ammunition to be sent together. So if you want to see the firearm, any ammunition has to come out, or vice versa. If you want to see the live rounds, then the firearms have to come out. That's regardless of the fact that we have 2 juries. Lastly, as you'll see and have seen in the jury room, you have a big smart television, smart screen, and some of the items and evidence you've received are discs, videos, audio calls. If, for whatever reason, you are having any IT issues, if it's not working or it's not playing, and we haven't had those issues in a long time, but if there are any issues, again, knock on the door, let the bailiff know, and we will certainly get you IT assistance to make sure everything is up and running. All right, so let's see if our alternate is ready to come out. Okay, all right. Then, ladies and gentlemen, you may take your notes, and you are now excused to deliberate. To leave your cell numbers with Madam Clerk in the event the jury has, oh, you're going to remain? Okay. All right, then why don't we transition over to Mr. Hakeem Robinson's jury? Are they all present and accounted for? Okay. We just need Mr. Hakeem Robinson. Okay. Oh, they're in 405? Oh, okay. Yeah, let's get him out first.
So, Your Honor, thank
Yes.
you.
Yes, all right, we'll take a brief recess. Everyone use the facilities, whoever needs to use them, and let's get the defendant brought out.
All right. So Isaiah in the comments is asking for predictions, y'all. So everybody, let's start with Scotty. On the count of murder, what is your verdict for Scotty? Drop it in the chat. If you are a member of the Taylor gang, you can use emojis. We do have a guilty, not guilty Taylor gang emoji. So if you want to use that to cast your vote, please do so now. All right, so we've had at least 5 people say not guilty, with at least 4 saying guilty. I'm voting guilty. I'm voting guilty on Scotty's on Scotty's murder charge. All right, let's go over to his burglary and home invasion. The burglary and home invasion charge. What is your vote on that one? Thank you so much, Kay. We appreciate you. Okay, so it's almost unanimous that everybody think he's going to get the guilty on the burglary and home invasion charges. This is where I struggle because I agree that they found his DNA inside of the car, It doesn't necessarily mean that he was in the car at the time of the murder, but in order for him to have run from the car to get into Barbara's house, he had to be in the car at the time of the murder. So that's why I go guilty on both sides. That's why I go guilty on both sides. Very, very interesting. Very interesting. Now, I know this one is going to bring the controversy. So, on Ksoo's first-degree murder charge, what is your prediction? Okay, so as I thought there's mixed emotions. We've got quite a few not guilties on Ksoo's murder charge, and we also have quite a few guilties on his murder charge. I go guilty. I go guilty because I think they put him in the car. I don't think that they proved that he was the shooter, but I believe that they put him in the car. And I think they did that with the phone. I think the cell phone really linked back to him, as well as Natalie picking him up. Those two things, I think, put him in the car at the time of the murder, and thus makes him guilty of the murder for being there, participating, lurking. You know what I mean? All of that goes to, planning and execution of the M. So I actually think they're gonna get him on the M. But there's reasonable doubt, though. I just don't think that they placed the reasonable doubt in the place where they should. They should have spent more time focusing on the phone data and the pickup versus his description, because it doesn't matter if he was the shooter or not. So that's just my personal opinion. Isaiah, I'm not going to be able to stream the Melly trial because I'm starting law school on the 18th. So in 2 weeks, a little bit longer than 2 weeks, but I'm so devastated too, because I did a lot of leg work keeping up with emotions and all the drama surrounding that trial. So I'm a little sad about missing it, but I'm gonna try and keep up, because I've got a commute. So I'm gonna try and listen to the trial in between classes and while I'm commuting, and maybe I'll be able to produce some recaps. Because we know that one is going to be the trial of the century. I got to actually go check in on them and see what's going on. Give my last update. Shay says she's looking at Ksoo as a principal as well. Why? Because of his DNA in the vehicle. You can't go on that alone, because that could have been there. I still have a problem putting him on the scene. See, them phones jacked him up. The phones did it for me, D-Wood, because that phone was linked to his Instagram that he had been communicating on for a few days. But we're going to hear how, or if, the defense tries to give a good explanation for what was going on with that phone. So I guess we kind of premature giving our verdicts, but we'll take a second poll after he does, after they finish their closing arguments. Hopefully Tara is doing it, because if Tara is doing it, she might sell it to a jury. We don't need Chris up. Chris did all a lot. He did a whole lot of talking. We need Tara to bring it on home. So we'll see. We shall see. Isaiah said, I want him free just because of his dad. Man, his dad is a piece of work, ain't he? He is something else. He is something else. I should just print this out and then take my test with it. I gotta do this test. I gotta do my final exam on that class that I told y'all we had to do. I'm finna print mine. I am about to print my outline that I made. Oh shoot, my printer not plugged up. Yeah, so I think tomorrow might be our last day of streaming, and I'll spend the last week and a half getting my stuff together for work, since I'm getting ready to embark on a new journey. So it just kind of depends. We also got to check in over on the Ali trial because it's early, so they haven't entered the courtroom, but it sounds like we're still on verdict watch. I think they're gonna get a verdict today. If them kids was a person, the dad is him. Oh no, for real. No, for real.
All right, before we begin, I just simply want to ask if, as you left here yesterday or arrived here this morning or during this overnight recess, if anyone has attempted to talk to you or approach you or share any information with you about this case or the people and places involved in this case. If so, please raise your hand. All right, for the record, I see no hands raised. Did anybody inadvertently or otherwise see, read, watch, listen to anything on TV, radio, newspaper, social media regarding this case or anything about the people or places involved in this case? If so, please raise your hand. All right, I see no hands raised. Thank you. So as you know, the state presented its closing yesterday, and at this time we'll call upon the defense for its close.
Thank you, Your Honor. The government didn't build a case. It bought one. An expensive expert, desperate snitches. But you can't buy your way past the truth. And the truth is, to quote Hakeem Robinson's sister, Blue's daughter, hell no. This is not the guy in the video. Let me walk you through some maps to explain what happened that day. Mike, if you would. So on January 15, 2020, Charles McCormick was at 7001 Merrill Road. Over at the Publix, you had Officer Jimmy Collins. At around 11 o'clock, Charles McCormick is shot and killed. The killers jump inside of the vehicle and they flee. Now, Officer Collins was fast enough, and you can see it in the dash cam video, that his car is parked down near that yellow line. He sprints. He doesn't run. His words. He sprints, gets into his cruiser, and gets behind that vehicle. And then there's a pursuit. They go out into Merrill Road, turn south, go all the way down to Townsend. Now, the first mark is where the car accident happens. A car crashes, 3 people jump out. 2 of them run south to Barbara Buckley's house. The focus for us here in our argument is the one that Officer Collins says runs westbound. Now, you heard some testimony. Officer Graham took the stand and talked to you about how he was in the area of Carlotta, saw somebody running westbound. Then, you also heard from Renata Boston, who lived at 7201 Arlington Expressway, that was also westbound. And then Natalie Gant testified that she picked somebody up. So our focus is on that person that ran westbound. Now, an opening statement, which feels like months ago, Ms. Kawas got up here and said, watch what the government's going to do. They're going to tailor their evidence. They're not going to give it all to you. When you trust the facts of your case and you believe that the facts of your case are going to prove it beyond a reasonable doubt, you don't tailor it. You give it to the jury. As a government, you give it to the jury and let the jury decide. That's not what we saw. Victor Kruger, he was back. He was in his vehicle. Dash cam, eerily music comes on when the shooting starts. He took the stand. The government didn't ask him for the description of the shooter. They left that out. I had to pull it out of him. I shouldn't have to do that as a defense, to pull it out of him, that what he saw was somebody that was very slight. Don't let this government get up here in their rebuttal and not answer the question to you why they didn't give that to you. Why are they tailoring it and giving you only the things that fit their case, but not those that are against it? Now, that applied to the witnesses as well, too. Jarvis Roberts, admittedly, he's far away, but he's a witness. Why did we have to call him? Jarvis, working at Hibbett Sports, is at his vehicle. It's only a couple of seconds. And he sees somebody and he describes it. It doesn't fit their case. They choose not to call that witness. I agree, they don't have to call everybody, but there's a handful of eyewitnesses. His testimony took minutes. Why did we have to call it? Don't let them get up here and not answer that question. Instead, they want to focus and get into a back and forth with Mr. Roberts that he was maybe 5 yards further away than he said. Was it 25? Was it 30 yards? Meanwhile, they're overlooking the inches and pounds discrepancy in between the descriptions in their case. Now, the reason why we're bringing the defense, we shouldn't have to, bringing all of these witnesses to you is for one simple thing. A dozen people, including police officers, are not going to consistently get it wrong. 12 people would have to be wrong, but consistent. Not tall and stocky, short and skinny. That doesn't make sense. Also, us as human beings, we understand that if somebody's running, that's going to drop their height. If they're far away, it's going to drop their height. I don't think that the people that are in the back of the courtroom are 12 inches tall. I have depth perception. I have the ability to be able to say, it's at a distance. But there are some people, when you get up over 6 feet, when you get up over 200 pounds, not a lot of beings are that size. And you can very quickly determine that is not a normal sized human being. That is not a normal sized human being. Stand up again. I'm a big guy. He makes me look small. Take a seat. So, talking about the witnesses that consistently, according to the government, get it wrong and describe somebody who's short and skinny. Michael Williams, military vet, undoubtedly has training in stressful situations. He gives a description that doesn't fit their case, so they don't call him. Maybe hoping that we won't call him. Why wouldn't they call him? His testimony was minutes. But he says stuff that goes against their case, consistent with everybody else. Next, we have Renata Boston. I'm sorry, I forgot somebody, and this one's important. Tashita Saunders. She was the one that was inside of the staffing place where Charles McCormick was right before. Now, anything that I'm saying here, I beg you, ask for the transcript. Fact check everything that I'm saying.
Yeah, sustained.
You've taken copious notes. I trust you remember the testimony, and you'll be able to fact check me in your own mind against the government. Tashita Saunders got up here, and the government questioned her. How tall is the shooter? Mr. Cooper then argued in his closing argument, taller than Charles McCormick. That is not what she said. We had to bring it out of her. Ms. Kawasa on cross-examination, 5'8", 5'9", skinny. It's as if the government is trying to blur the lines to increase the height of the shooter and decrease the height of my client because it's the only way they can bridge that gap. We shouldn't have to give you what is the truth of what the witnesses said. Tashita Saunders said 5'8", 5'9". Not because if you say taller than Charles McCormick, well, that could go all the way up. She put a cap on it. We shouldn't have to bring it out. Now, Renata Boston. Renata Boston was not upstairs and ran downstairs. She was sitting on a wall talking to her friends. She sees somebody come out of the woods. She also gives a description that we had to get out, which is consistent with everybody else, short and skinny, and also the same height that Tashita Saunders gave, which was 5'8" to 5'9". We shouldn't have to pull this information out. Your government should give you the objective facts and let you as the people decide. By tailoring it, they're not doing their job. Now let's talk about law enforcement. So let's talk about then Detective Collins. And let's contrast that with reasonable witnesses, objective witnesses. You remember earlier in the trial, there was a couple of crime scene techs, the DNA people, the fingerprint people. That is objective evidence. Objective witnesses, when they testify, they answer the question straight. They're not trying to, find the answer. Contrast that with Officer Collins and also Officer Smith. Now, on Collins, we know, and we have the CAD notes. 5686, on his direct examination, the government got that out, that's his badge number. I'll zoom in here for you. He gives a description of 5'5" to 5'9". I don't buy it for a second that, well, you know, I'm not sure. He could have just said, black male with this type sweatshirt running, unknown height. But he gave a description. Because the reason why you wouldn't do that, then if there's anybody tall, that's not the guy we're looking for. He gave the description that he had in that moment. He tried to be cagey. Compare him to how the texts were. We asked a question, the DNA expert. It could have gotten on there because of the t-shirt. Yes. Instead, him, from the very beginning of the cross-examination, he showed that he was motivated. When I asked him, and I go, you ran track and field, he paused because he knew that that was going to be bad for his testimony. I then asked him, you have to think about whether you ran track and field? And then he goes, well, you know, that was years ago. I'm not saying he's as fast as he was. I'm just saying that he's faster than this guy. 6'4", long legs, former runner, fit as anything as he took the stand. He wasn't giving straight answers. Most importantly, we heard from Detective Smith, body cams. Where is Officer Collins' body cam that would have shown who he was chasing? At one point in his testimony, he talked about how recently he looked at the video and, you know, he determined that he was wrong. You know, people ask a question a lot on how wrongful convictions happen. That's how it happens. Because witnesses on the stand, Ms. Kouas and I have lived this case for years. We know the facts. And when he testified to that, you probably saw us jump up and our faces go beet red.
Yeah, sustained.
You saw the evolution of his testimony. He did what we're saying that the government is trying to do. They're trying to increase the size of the shooter to fill that gap. But what he doesn't realize is where he thinks that he's growing the height of the shooter, it's actually his own nose like Pinocchio. Because his lies, his attempt to lie, actually prove our point. Now the government, they showed a very small photo. This is their exhibit focused in. There's your shooter. All right, you can see right above him a black line in a window. That's Officer Collins. Now, if you toggle back and forth, you'll see that the shadow of the two is different. Now, I'm just pointing out a fact on what they didn't do. They talked about how there was a gradient at Renata Boston's home. What we don't know, and what we can't tell, is if that is perfectly flat, if there is a drop-off, even of an inch, from the driveway to the grass, and whether the grass is flat. I can assume the driveway is flat. But there may be a slight deviation. Now, in a case like this, an inch matters. But when you go back and forth between these two, it's important to notice that the shooter, and we'll talk about this in a moment, has something up underneath their hood. Latham testified that that would add easily a couple of inches. Now, Officer Collins got up there and said that he's 6'4". He looked about that, maybe 6'3". Sometimes, you know, guys will exaggerate, round it up, round it down. When you compare the two and put them side by side, and I'll draw a line in here for the window, right? And then I'll also do it for the window on the other side. So that's our point of reference. Now, if we estimate where the top of the head of the shooter is, because of what they have up underneath their head, that brings them roughly to the chin of Officer Collins. I don't know what the length of the average human head is from the top to the bottom, but I'm thinking it's at least 8 inches, 10 inches. They were hoping you wouldn't look at this closely, that he could just come in here and go, oh, I looked at this video years later, this very grainy, difficult to see video, and you want to know what? I was wrong. He was my height. That's preposterous, and the evidence shows that that is preposterous. We also heard from Officer Graham. We had to call him. They didn't. That's a police officer. Former police officer. We had to bring him in. He's one of the 2 police officers that chased on foot the shooter. Unquestionably chased the shooter. Why are we calling that witness and why are they not? They're not calling the witness because of the height description that he gives. It conflicts with their case. It's consistent with all of the civilians that we brought in, all of the civilians that testified, and Collins. The important thing is this. Any big guy knows this. There's no way a guy that's 6'2", 6'3", 230 is going to outrun a cadet that had just gone through the academy, that is going to outrun a former track runner. That's going to be, and remember what Graham said, he was jumping fences. He was fast. They were even in their cruiser for a moment trying to chase him. He was that fast. That ain't him. Again, quote his sister, hell no. What was Hakeem Robinson like then? The government wants you to, say, well, photos didn't need to be taken. Remember, we're the ones that brought in the photographs the day before. We're the ones that had to bring that in, and we also brought in Howell. But if we look, this is when the scan is done, the big piece of the government's evidence. You see the build on Hakeem Robinson. Now, there's little point of reference here. If you put him up to, next to Miss Quas, a normal-sized human being, he's huge. But even in this, you can tell he's got a belly. He is out of shape. He is not toned. And, Your Honor, I hope that I can quote what I did the other day when I said the shooter ain't got no ass. He does. In the video that we had to enter in from the JSO property room where they show, and it's in evidence, you can look at it. I'm not going to play it now.
I'm sorry, I missed what you said.
Entered into evidence as Defense Exhibit 3. He had to enter it.
Okay, I'm going to sustain the objection.
You can review Defense Exhibit 3, our exhibit. It shows Sergeant Howell walk out. And Sergeant Howell's 6 feet tall, like 300 pounds at the time. And Hakeem Robinson's taller than him. But you'll notice something as he's walking. Now, admittedly, he's wearing slides and he's walking. But big guys know this. They waddle a little bit. You ever seen a linebacker, the way that they walk? It's not the same as somebody who is fit and who is fast like the shooter. And you can see it. He has sort of a duck waddle in the way that he walks. It's a product of having big legs and being a big guy. Now, so in our exhibit we brought forward, now the government had an issue. Because Renata Austin says the person that walked out of the woods had shoulder-length dreads. Now, the government, they showed you an exhibit when my client was getting a pedicure, not a couple days later, it was almost a week later, 5 days later. And they showed from an angle of down where the hair, and one could think that looks like hair that's down to the chin because of the perspective of it. Our exhibit, our videos, shows what his hair was like 18 hours before this crime that he's accused of. He had short hair. He did not have shoulder-length dreads. There's no question. He did not have He did not have shoulder-length dreads. He had short twists. The government, though, has tried to fix this. They brought in a photograph. Of all of the photographs on Hakeem Robinson's phone, there were thousands, over nearly 5,500 photos. They find photos of the hood. They only show you a few of them. They tailor it. But again, this supports our argument. Now first, before I get into this, you look at the music videos, You notice, your times out in public before, he's not the only one with hair. If you look at the different type hairstyles in Charles McCormick's music video, in Hakeem Robin's music video, there's a lot of people that have long hair. But this proves a point if we jump into the details. You notice how Hakeem Robinson, because he has sort of a uniform hairstyle, that the back of the hood looks as if it's empty. Now, obviously, it's lifted up off his head, but the back, it's got just fabric. You compare that over to the shooter, that is a different head. That is a full hood. That is hair, that is something up underneath there. Not that hair. Those are not, I'll go back and forth, those are not the same heads. Mr. Cooper got up on his closing argument and he said, Hakeem Robinson is 6 feet. And again, we're talking about tailoring the evidence, trying to shrink Hakeem Robinson, trying to grow the shooter, trying to jam a square peg into a round hole. That is not what the evidence was. The evidence for his height from first Blue, are we to trust him or are we to not? Because he said 6'2", 6'3". Johnny Shipes, no motivation whatsoever, not in handcuffs, not looking at prison. He said, I'm 6 feet. He's a lot bigger than me. He doesn't even fit into my clothes. Latham got up on the stand. And that's not what Latham testified to. He goes, the government did not ask me to do a height assessment. He agreed that the poor posture, not measuring for height, was 6 feet and a quarter inch. But he also said that there is an error of margin, very small. And we talked about the black tape line. I asked him, and I go, how thick is that tape? And he goes, could be 1 inch, could be 2, could be 1.5 inches. Again, I wasn't asked to do a height assessment, and you can clearly see that Hakeem Robinson is taller than that. And then anybody knows, you get your height measured. When you go to the doctor's office, that little square is so small, so it forces you to put your feet together. You can get an accurate weight, can get an accurate height. Again, they are trying to shrink Hakeem Robinson to fit. Stand up. You don't have to go based on that. You can look at him in this courtroom and make your own determination on the size of this man. Sorry, if we can back up. And also the size of his feet. You can make that determination on your own. And when you do that, you can take a seat. Go back and look at the tiny little feet on the shooter. Latham said he would have the ability to be able to figure out the length of things. He spent nearly $100K on that guy to get up here and say, yeah, maybe. You don't throw in a few more dollars to get an accurate measurement of that foot? Let's go now to Sergeant Smith. February 5th, he's already committed on who it is. That's not an investigation. Literally days later, he sees an Instagram post. Now, what he says is, I screen recorded the Instagram post. We don't have the other Instagram stories to know what other things were out there. He just found one and he's like, this is enough. And he then commits to subpoena the meta records of my client. He had a print before that. We embrace that. That print was on that gun. It doesn't mean that he was ever inside of the car. And you know that he was in a music video holding all his buddies' guns. He was committed at that point in time. Print, post, he was done. His job was done. That's my case, but it wasn't enough. We got to build it a little bit more. Now let's compare this over to the other people that we know were involved. Barner, Butter, Blue, Abdul Sr., Abdul Jr., Torgon Williams, Natalie Bryan, Chris Brown. None of them posted anything. We use a phrase in these courtrooms every now and then, consciousness of guilt. That's consciousness of innocence. I'm going to post something, would be wildly, days later, wildly stupid. The only person that's going to do that is somebody who is confident in their innocence. I am using this because this, unfortunately, and look, I don't condone it. I'm not a drill rap fan. It sells records. And it gets followers. But him co-opting a lifestyle of people that grew up around him as an artist doesn't mean that he's the one that committed it. I mean, look, country music stars talk about, murder. And look, I understand somebody actually died here. Rock stars will scream about murder. Other rappers will do it. We don't say that's a confession. But when it's a 21-year-old black kid from Jacksonville, it is. We're talking about the government and the way that they're trying to tailor the evidence. An opening statement. Mr. Cooper got up here and he showed you that post and he read it. I am never going to read that post. I don't have that right. First, they're assuming that's what it means. Right? Somebody could have a good day in court, post online, I killed it today. All right, so they want you to speculate that's what it means. But let's assume arguendo, that's what it means. So the government gets up here and they go a couple days later. A couple is 2, not 5. And then he says, getting his tired feet to try to say, oh, he ran and then went and got a pedicure after that. Again, 5 days later, nobody else is posting stuff. Everybody was trying to get away with his crime, and apparently he just goes out on public to his hundreds of thousands of followers, JSO watching, and confesses. The problem is that, look, there's 2 ways that you can look at the world. You can look at it through clean windows or dirty windows. You look at the world through clean windows, you're looking at it objectively. You start looking at it through dirty windows, everything you see is dirty. And that's what former Detective Smith, now Sergeant, did. He committed, and everything he looked at for Hakeem Robinson was through dirty windows. He was a hammer. That kid was a nail. He didn't look at anything else, despite the fact that there is clearly motive of other people. Chris Brown. We're not arguing that Chris Brown is the one that committed. I don't come into court and make speculative allegations. There was more than enough to look at it. So, Chris Brown. Renata Boston says that the guy that comes out of the woods has shoulder-length dreads. Natalie Gant gave us that little tidbit as well, too. Oh, yeah, shoulder-length dreads. Didn't have shoulder-length dreads, not even close. Butter pecan skin. Now, it's clearly more brown than it is my client. I can't say that I confidently know what butter pecan skin is. I'm thinking of ice cream, but I'm thinking that it's more close to this guy. But there's one other glaring issue with that. Rothermill case. The murder crew is blue, butter, and brown. Crazy Chris. They literally have another murder case tied to Willie Addison. Smith gets up here and he goes, I don't even know his phone number. Talked about it in voir dire. You have to objectively investigate. You can't commit to a case, to a murder case, that is going to change the lives of so many people 2 weeks into the case. If he were looking at this case objectively, he would have looked into Brown. Oh, and don't forget, and I almost forgot this, Barner said Brown was involved. Now, someone asked, well, why would Barner do that? I'm not asking you to understand the motives of a reliable hitman. I can't get inside of that guy's mind. I don't think any of us can. But is it crazy to think that in his mind he's thinking, first, I got to go with their narrative. But also, the more people I give them, the better my deal's going to be. Yeah, Chris Brown on 2 cases. That's not going to do much. But if you get more people, you can say, I gave you all of these people. There was plenty of people that had a motivation. It came out through Latham, it came out through Brown, it came out through other witnesses, that there was plenty of other people that would have been upset with what Charles McCormick did. None of them were looked at. None of them were evaluated. Instead, they spent $100,000 to say that it wasn't 2 other people that we were never arguing that it was. They never acquired any records of Chris Brown, his Instagram, his cell phone records, nothing. Same thing with Dominique Barner as well, too. They don't get his Instagram stuff, and he said that he was on Instagram. He used it to stalk his prey, and also his iCloud stuff. It's willful ignorance. Now, I'm not saying that Smith sat down and go, you know what, I'm going to jam this kid. I'm going to make a choice not to look at it. But he lacked all objectivity within minutes on the case and didn't look at anything else, wouldn't even consider it. Let's change gears now and talk about House of Pain. So we're going to go into the topic now and talk about all the communications and the cell stuff. The government, like they're trying to link, they're trying to shrink Hakeem Robinson, grow the shooter. They're trying to bridge a gap as well, too, with the cell phone communications. They're invisible dots, imaginary lines. They're trying to get you to speculate. Now, first, they're trying to both say that, Hakeem Robinson was involved, that 478-305-9583 number, that was his, that he was using it. They're trying to connect all of that. But that's not what came out. They'll argue it, but it's not what came out, and that's why we're going to go over it here. First, with respect to the House of Pain email account, and they're trying to say, well, there's selfies of Hakeem Robinson in that account. Now, we know that Blue was trying to be the manager of his son, especially when his career was taking off. And any Apple iPhone user knows that you can combine, you can share photo albums. You know what makes sense as well? Something that they haven't disproved because they didn't get any of the further records, that he's uploading photos to his father's account so that his father can manage his Instagram page, to do something as a manager to justify getting payment. I'm not saying that's what happened. I'm saying that there is a hole in there that they're saying, well, they're selfies. It must be his phone. It must be him that's doing it. They could have gotten to the source of it. They could have gotten the Gmail records for that account. They could have gotten Blue's Instagram account, literally HOP, House of Pain CEO. But they didn't. Some could say willful ignorance. I'm saying that it's Sergeant Smith, Detective Smith deciding. It doesn't matter. I'm committed on what it is. Now, there's anomalies within the cell communications. Now, they've never actually tied Hakeem Robinson to that 478-305-9583. Smith got up here and he tried to say, well, the IP address, the first 4. He's not an expert. We heard from 2 other cell phone experts. They were never presented with that information. He tried to say, well, the provider told me, that's hearsay. The provider told me that, it's the first 4, not the last 4, but I subpoenaed the wrong one. It was a 7, it was a 1, but yeah, it could be. Now, the government tried to say that based on what he said, it's a link. His words, could be. But even that is not even close to a connection. They had an FBI cast member agent up on the stand, didn't ask him any of those questions. You best believe that if they tied the IP address of that phone to my client, you would have had an expert from T-Mobile sitting in here going, here's your link. But instead we had Smith get up there and go, yeah, it could be. They're trying to blur the line, trying to connect him to the shooter and the phone to Mr. Robinson. Blue says that he was worried about his son. Given his testimony, I don't think he cares about his son at all. But he says, you know what, I cared about my son. Whether it's him caring or not, there is not a single phone call to that number. You would think that if this is the phone that is being used in the commission of the crime, that somebody would be repeatedly calling it. Now they'll get up here and say, well, it could be a FaceTime call, we have no record of it, a data vet. Translation, they want you to speculate. They have never connected that phone over to the shooting. There are communications with one of the people much earlier, not during. There's a pin drop, could be in an area. They're wanting you to speculate. They need you to speculate because they have not made the connection. You remember, too, that they have the color-coded, they may show it to you here, that the red stands for that they even want to connect it before they've connected it because the 478 number is in red, and so is my client's known 1595 number. They have it both in red. The interesting thing is that throughout the entire time of the commission of the crime, you see no red. It's everybody else. Now, there was mistakes and anomalies with respect to the cell communications. First, Natalie Gann, glaring mistake. The cast agent, 7259, 7529, they admit it was a mistake, it wasn't entered incorrectly. Look, in other lines of work, could it be a scrivener's error? Oh, I thought you wanted it medium rare, not well done. In a murder trial, when you're trying to explain, to have a jury make a decision beyond a reasonable doubt, there's no mistakes. That was a mistake. And then we also have the anomalies with AT&T. And he said it, he goes, look, we can't, 95, I forget what the exact percentage was, but he's like, we don't use it because of the anomalies. But they still want you to trust some of the AT&T records. So, staying on the topic of the phones. Now, they brought up in the closing argument that Abdul Jr. had a phone that was registered to Darrell Watts, and that the 478 number was tied to Darrell Watts. What they're leaving out is that Blue's main number was also registered to Darrell Watts. They also brought up this exhibit. It's a nice picture of Blue. He looks like he's, indecisive, not the felon that he is. And they said, he's not going to send a message to himself. His email is literally right there, as if you're not going to see it. It's insulting. From his number, 2370, which is under Darrell Watts, sending it to 9583, and Abdul Robinson 71 at Gmail. Abdul Robinson Sr., born in the 70s, definitely not my client's email. They showed you this photo and made the argument he'd never send it to himself, where literally it shows that he sent it to himself. Talk about the DNA and the fingerprints. We, of course, embrace there is DNA on a shirt. I think it may be out here, maybe over there, but with the white shirt. Doesn't prove that he ever wore it. We talked about it with the expert. If I were to take my client's handkerchief and wipe my brow, my DNA is going to be on it. And she also testified how that very easily could be the reason why there is a mixture, because they take a swab and they do the entire compartment, and that very much could explain, well, the t-shirt's sitting there, then we wipe everything, why there's a mixture and why it's so low. But we embrace that. His DNA is showing up on a shirt that's in the car and also on the dash. He was friends with these people. He rapped about the life that he lived. We are not denying that. He was around them. He knew them. Wasn't doing what they were doing, which is why he isn't covered in tattoos and bullet holes, because he's not living that life. Fingerprint, the music videos. So again, we embrace this, but none of that, and I don't need to go over it because I know you saw the testimony. But they both agreed objectively in their testimony, I cannot say he was ever inside of that vehicle. What we know is that his fingerprints are not in the vehicle, and there is not a 700 billion DNA reading of inside of the vehicle. There's a small mixture. The DNA expert got up there and said, yeah, it easily could have been transferred by the t-shirt. The reason why the government's probably arguing it is because they know jurors like DNA and fingerprints. No, it's like that silver bullet, but not here. This means all it proves is that he knows people that we already agree he knows. The other evidence shows that. So don't let them sway you with the idea of DNA and fingerprints. Same time too, we have Chifton Hogan. If their rationale of anybody whose DNA is found inside of the car, well, they must be involved. Chifton Hogan and Blue said, oh, yeah, that's a family member to some extent. Anything that supports our argument that if you know people, your DNA could show up inside of their vehicle. Talk about witnesses in this case. Latham, the expert. The government, and I said this before, they paid $80K, $70K, $80K, I don't know how much his expenses were flying back and forth and lodging, to come in here and say, yeah, maybe. Meanwhile, all of the witnesses consistently describe somebody that's short and skinny. Then they arrest a guy who's 6'2", 6'3", 230 pounds. That's not how the truth works. But desperation looks. Latham up on the stand, and I asked him, and I go, can you exclude me without scanning me? His answer is no. And from that you can take, there's nothing unique about what he's saying. He can confidently say, well, it's not Leroy Whitaker, it's not Dominique Barner, not being argued here. But nothing more. Now the government, in their argument, they have brought up this photo. Now we have to talk about Charles McCormick's height and weight. Latham said, well, they provided the information to me and I do the analysis. And what they gave me is that Charles McCormick was 5'10". There's a problem with that though, because I had to bring it out through the medical examiner, and he goes, that's just an estimate. Post-mortem, there are differences. Could be 5'9", could be 5'11". Also, this person is wearing shoes. So when that was brought up with Latham, he goes, I was given 5'10". I then. They call the medical examiner, and the medical examiner tells you that's not, I can't say that's an accurate height. But they want to do this comparison in between somebody who's 5'10", and then over to the shooter. We know that Charles McCormick was 143 pounds. We know that definitively. When you compare that over to the person next to him, now, Charles McCormick is obviously turned a little bit, and they're not in the exact same posture, and I'm not denying that. But I could also make the argument that he's wearing darker clothes, which makes things look smaller, and the shooter is wearing light clothes, which make things look bigger. What you don't see is a huge difference, 100-pound difference between the two people. See two skinny guys. Also, as for the height, yes, they are moving, they're dropped down. Let's do some math here. Hakeem Robinson, let's give him an inch, we'll say 6'2". Shoes, that's another inch. So he's at 6'3". Add then 3 inches on top of the head under that hood. That person's pushing 6'5", 6'6". If that were Hakeem Robinson next to Charles McCormick, 5'9", 5, whatever it is, he would be way taller. He's not. Again, the government's trying to shrink it. They're glossing over the 3 inches that Latham said, yeah, that could easily be 3 inches on top of his head. I submit to you it could be more. If Hakeem Robinson, those little tiny feet, there's no escaping those little tiny feet. If you add an inch onto him, 6'2", 6'3", then whatever's underneath that head, that person is going to be a giant. You are not going to mistake that person for short and skinny, not a dozen times in a row. But they want to get up here and say, Charles McCormick, 5'10", despite what the witnesses said. Hakeem Robinson, 6 feet. They're tailoring their evidence because they know that the evidence itself, the facts, suck. Now, they may get up here and say, well, you know, we didn't need these witnesses. You cut a deal with violent felons and you don't need them? You cut a deal with Barner, who's a reliable hitman. You only get the reliable hitman term if you have killed. We know that in these cases, there's nothing to establish him as a reliable. In Rothermill, they killed the wrong person, an innocent guy in a bike. On this one, he gets caught, but he's a reliable hitman. Sounds more like he's a serial killer. They may get up here and say, well, you know, we didn't need these witnesses. Our case was strong enough. Then why cut those deals? He could be out in a matter of years. Blue has a likelihood of being out in a matter of months. That's desperation. Don't let them get up here and say, well, we didn't need it. They did. That's why they cut reprehensible deals with violent criminals. There's an internal conflict with their testimony. Right? Now, they're felons. They're cooperating to get a deal. Let's put that aside for a second. So Barner gets up on the stand and says in the Rothermill case, implicating Blue on how he could have been charged with much more than accessory, provided items. Blue got up there and he denied. So which one's lying? It's not our job to prove it, it's theirs to prove, okay, well, this one's lying, but that one's telling the truth. As it stands before you right now, you have no idea. Schrodinger's cat. You have no idea who is telling the truth. But they want to put them up. They want you to trust these people, that they're pillars of truth. Because they came to them in handcuffs. Don't trust Johnny Shipes or Blue's daughter, who have no motive, and if anything, reasons not to come forward and testify. Mr. Shipes, Mr. Shapiro, because of his business. Blue's daughter, because she's basically saying that her father's lying in front of the judge that we'll be sentencing him. They have no motive. But no. Trust the people that came to us in handcuffs. Trust the people that we have on a physical leash to tell the truth. And again, we set aside the fact that they are murderers and felons. Don't let them get up here and tell you they're both telling the truth, that either of them are telling the truth when they didn't clear up that internal conflict in their own testimony. Now, Natalie Gant, they said in their closing argument, well, she had no motive. She absolutely did. You could see it on cross-examination. I could feel the breeze from her lashes fluttering at counsel table as she was getting cross-examined about the motive that she has. Now, it's not about what this government thinks. They sit there and smirk at you. It's not about what they think. It's about what that witness thinks when she's sitting on the stand. She knows Dominique Barner has implicated me in this case. I don't want to get charged. I'm going to do whatever the government says. Oh, and her husband sitting in prison being prosecuted by their office. It's about what's in her mind and the reason why she would have to tailor her evidence. Now, the government says, well, she didn't have all the details. She's older. She's not like the men she dates. She's smart. She knows if she commits too much, it could actually cause a problem. Oh, I don't remember what he was wearing. As if she were to say the wrong thing, and she's not usable. She hurts their case, potentially gets them mad, which is bad for her, in her mind, and her husband. The handguns. How would Barner know to say that the handgun was, look, Barner is not, I'm not saying he's book smart, but he's definitely street smart. He knows that there was, okay, and he was sitting on his case. He was getting prosecuted for months, looking at discovery before he ever made the decision to flip. He was arrested on the home invasion robbery. He had a whole bunch of records, and we're going to come back to that, on how he could have done what he did. But why would he claim that gun? Well, he knows that there's 3 guns in the vehicle. All right, one of them was used to commit a murder. The other one is a big machine gun. Yeah, that one's mine. Gave him musical chairs. He had to claim one. 3 people in the car, 3 guns. That one's mine. I'm not saying that the government, and if it's ever come off like this, I want to make this clear. I'm not saying that the government sat down with these witnesses and said, we need you to say this. Not saying that. Never would. But what I am saying is that they gave an opportunity to some really dangerous people. Dominique Barner is resourceful. He went on the court's computer system to stalk his prey, created fake Instagram accounts to figure things out in locations. He has a discovery on his case. We know that the first thing that was collected by Sergeant Smith were my client's meta records. The very first thing. Florida is a discovery state. This guy wants the government to be happy with him. It gave him too much of an opportunity. Now, the argument that we make over the recording, look, and we won't say it, the government has a right to talk to their witnesses. They're doing the work they need to do. They're talking to their witnesses. That's not our problem. Our problem is that in the second time they spoke to him, we have no idea what happened. Now, again, I'm not saying that these prosecutors told him what to say, but I do have any concern when the government is doing things behind closed doors, our government, without an ability to see it. And when they spoke to Dominique Barner the second time, Sergeant Smith told us they were leading questions. If you're getting the truth out of somebody, you don't have to lead them. You were driving the car. Hakeem Robinson was in the car. They're giving an opportunity for somebody to say the facts that they know the government wants to hear. And that's a problem that I have, that they allowed him that opportunity. Somebody that they knew was dangerous. Look, that serial killer has no problem taking a life. He has no problem lying to save himself. Sadly, we have no recording of the initial meeting. We don't know how he was able to get his facts straight, but I do know meta records are in the possession of law enforcement months before he cooperates. Florida is a discovery state, and he gets up there in another one of those times where we get new testimony. Oh yeah, he called Raekwon. You can clearly see that in the records. But what the government won't embrace is that my client's regularly talking to Raekwon, somebody that he's supposed to have a problem with. What that proves is he doesn't have a problem with these people, which is why he doesn't have bullet holes in him, that he's not living that life, that he's not tatted up. And we also know, because after that, Raekwon Howard tried to kill people that we know were involved. Didn't go after the guy that he's talking to regularly and joking around with. So, it's very easy for somebody like Dominique Barner in a meeting. You know, Dominique's sitting there. Did Hakeem make any phone calls in the car? In the questions being asked by a prosecutor that's holding a stack of papers. Barner's smart enough to go, yeah. It's that simple, and it's that easy for that to evolve into, yeah, he was talking to, yeah. And that's ruling out the fact that he has the records. He was involved. He's going to get some of the facts correct. But he's also resourceful, again, on hunting his prey. This time, the prey was Hakeem Robinson. Now let's turn to Blue. Sat up here, fake tears, my son. Y'all saw it, there was no tears. He had that emotional pause. Yet he had no emotion when he was talking about the murder of his other son, Willie Addison. Abdul Robinson's daughter, no motive. If anything, reasons not to. I mean, of course, she doesn't want her brother wrongfully convicted. But she has reasons not to testify as well, too. Jonathan Shapiro, Johnny Shipes, no benefit, risk. Both of them gave a description of the height and the weight of Hakeem Robinson around that time. And it's inconsistent with what the government's saying. So, the government may get up here and talk about the fact that Barner and Blue are not sentenced yet, and that they don't know what they're going to get. That's by design. They got to make sure that they're dangling that carrot in front of them so that they do what they want them to do. It's also so that you as the jury don't hear what is potentially an offensive sentence that they get because of their recommendation. They want you to think, well, they could get life. There's no reason why they couldn't have been sentenced before coming in here. Now, one thing I want to go back on that I did miss. It's a really big point. And it's that both of them said, in government, I invite you to get up here and explain this one, that both of them said, Dominique Barner and Abdul Robinson Sr., have to say Ksoo to get the deal. Those are their words. I have to say Ksoo to get the deal. Let's talk about the jury instructions for a minute. I'm almost done here. So, when you go back into the jury room, one of the instructions you're going to get is weighing the evidence. And this is an opportunity for you to evaluate a witness's testimony. And these are things that the law in Florida says you got to be cautious of. We need to point this out to you because this could lead to a miscarriage of justice. Did the witness have some interest in how the case should be decided? And they're not spending life in prison. They're not getting prosecuted on multiple cases. Does the witness's testimony agree with the other testimony and other evidence in the case? I submit to you it doesn't. There's not massive conflicts, but there's definitely irreconcilable conflicts between their testimony. Has the witness been offered or received any money? We've already talked about Latham. Preferred treatment or other benefit in order to get the witness to testify. We are going to charge you with principle to murder. You're looking at life. You're a convicted felon 2 times prior. If you say what we want you to say, we'll recommend 72 months. Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? You'll get out in 72 months, but you got to say Ksoo, or otherwise you're looking at principle to murder. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Yes. Has the witness been convicted of a felony? Both of them, yes. Just one of these is enough. They're hitting almost all of them. They're not just felons. They're not just convicted felons. They're felons who traded a story for a deal to save themselves. They sat down with the state and told them what they wanted to hear, not because it was the truth, but because it was the price of their freedom. It's not justice. Bargaining with guilt. The government wants you to trust them over all of the other objective, unbiased, unmotivated witnesses. That's scary. You know, the government, they may get up here and talk to you about reasonable doubt and say, you know, look, my job is I got to get you in a boat across this river. There could be holes in the boat, but I got to get you across the river. Now, I want to change and use that example, instead talk about waiver and vacillate, because that's what reasonable doubt is. You're standing there on the shore, you're looking at the boat. The boat got some holes, some water's coming in. You're told that there are anomalies with the boat, it was manufactured incorrectly and there's problems. Any reasonable person's going to be sitting there going, I don't know. That's waiver and vacillate. But add on top of that, the two people that are captaining the boat are violent felons, and they're telling you, hey, this boat's fine. No reasonable person's getting into that boat, and that's what they're asking you to do. Let's talk about their burden of proof. I'm not going to go through this or spend much time on it, but just for the illustration of what we're talking about beyond a reasonable doubt. Everything else below that, strong belief, guilt likely, probably guilty, possibly guilty, none of that is enough for them to carry their burden. They have got to be able to rule out every other possibility. But the case that they presented to you, there's a whole bunch of other reasonable ones.
All right. The jury will listen to the instructions as I provide them to you, but you may proceed with argument.
They can't carry that burden. They have too many holes in their case, which is why they're not embracing the actual facts of the case and instead trying to mislead you. Now, whomever from the government gets up here and does a rebuttal may try to sway you with emotion, show you photos of Charles McCormick, talk about the tragedy. So let me save them that time and do it here for you. What happened to Charles McCormick, what happened to his family was tragic. No parent should have to bury a child. It's horrible. Convicting the wrong person doesn't fix that. It makes sure that the person that actually committed it, or other persons, go free. It doesn't protect us here in Duval County. Hakeem Robinson deserves better. The people of Duval County deserve better than Detective Smith getting up there going, yeah, that post is enough. The McCormick family deserves better than that. The emotion of this, the understandable emotion of this case, though, there's no place here. That's an attempt potentially to sway you into a verdict because the facts aren't enough to do it. So I'll save them that time of making that argument. A short amount of time, you're going to be back in the jury room, you're going to be deliberating. You're going to be asked to make a determination whether Hakeem Robinson is guilty or not. Again, to quote his daughter, hell no. Thank you.
All right, ladies and gentlemen, I'm going to give you a short bio break since we've been going for over an hour. So I'd ask that you leave your notepads behind, to have a step into your jury room, and then we will return with the state's rebuttal and the court's instructions on the law. Thank you very much. Take your seats. At this time, I'll call upon the state for its rebuttal close.
May it please the court.
Yes.
Counsel. Ladies and gentlemen of the jury. I am going to show you the last photograph taken of Charles McCormick. I am showing you this photograph because that's what this trial is all about. It's about seeking justice for those brutally murdered. I show you this picture not to inflame your passions and make it so you find somebody guilty. I do it to specifically rebut a comment the defense counsel made. Before we go into that offensive comment, I want to say this.
Objection to integration of counsel.
Overruled.
What I am commenting about the defense, I wholeheartedly believe in the Sixth Amendment of the United States Constitution and Mr. Robinson's right to have all the witnesses against him cross-examined by a zealous advocate. And that is what we did. My criticism is not that they have tried to do their job. My criticism is that the defense stood up here after the young black man investigated by a black detective tried to imply that this case is somehow about race. Somehow country singers or hard rockers don't get investigated, but only young black men that do rap songs do. That's not true. Detective Smith poured out his life into this case for hundreds and hundreds of hours. And he didn't do it because of the race of the victim. He didn't do it because of the race of the victim. He did it because Lady Justice is blonde. This courtroom doesn't consider those things. This courtroom says that that bias cannot come into your decision-making. Judge Salvador will tell you as such. This is about whether or not the state has proven its charge beyond the exclusion of every reasonable doubt. And we embrace that burden. It is not about young black men that rap, somehow us taking it out on them. Charles McCormick. You're going to hear a common theme throughout my rebuttal argument. Hakeem Robinson is either the unluckiest man who has ever lived on the face of the earth, or he's just plain guilty. The vast majority of the defense closing argument is about how an incredibly lucky piece of evidence, the dash cam video, somehow implicates that we have the wrong guy. That's been their defense since day one. Countless parts of his closing argument are about that. January 4th, January 14th, January 15th. It's not just about hairstyle underneath the hood. He screams over and over and over again, 6'3", 230. And then we have the photographs that show it's just not true. It's just not true. We have digital laser scans that say it's 6'125". one of the reasons I'm showing you the two different views from Defense Exhibit 3 is to show how the light can affect how the sweatshirt looks. It's 3:2:30. Because Hakeem Robinson, months before, a couple days after, wearing pinnacle. I see what it is. The evidence proves that's the same sweatsuit. Tell just from that picture, no. But it's a pretty dang good piece of evidence. In the video, God bless, dash cams, surveillance videos, DNA. I've been doing this long enough that I remember when we didn't have all those things. And it's made our job a heck of a lot easier. And more importantly, it's made your job a heck of a lot easier. Because artful defense attorneys pounding their fist on tables, which they should do, their client. All of that doesn't change that a picture can tell us 1,000 words. In this case, it tells us one. You're talking about Slender, these poor witnesses. Okay, challenge number one from the defense. Get up here and explain why you didn't call witnesses that were working out in Bailey's and looking through glass. He said, he said there's clean and dirty windows. Was Mr. Williams looking through a clean Bally's window or a dirty Bally's window when he was half a football field away with a guy crouching down? That his testimony to you doesn't help you make this decision because we have a video. The descriptions are totally irrelevant in this case. Yeah. They stand up here and argue. How dare we pay $70,000 to $90,000 for a paid extra? We're just buying our conviction. You know who deserved that? Hakeem Robinson deserved the state of Florida to spend tens of thousands of dollars to figure out if all these descriptions, and mind you, they're not all. People that are closest put it right on more better descriptions. And when you look at the photographs of him at the time, he's much smaller than he is now. But regardless, we wanted to invest that money. The defense attorney gets up here and glares about how concerned he is with the government. Know that your government spent your money to make sure that all the corroborative evidence was right. That we could exclude Barner and Whitaker from that video. By the way, they match the description that everyone gives. We're going to put so much stock into these. They match it. And we invested that money to see. He's never going to be, no expert's going to be able to look at those and say they identify a particular human being. Does the body morphology? He says there's no way these two guys that match the description of the shooter given by people who admittedly don't know and are guessing at someone crouching after they watch a shooting for 2 seconds. Deserved that money. Deserved every penny of it. We give that to you so you can have confidence. All the other evidence. Oh, little something. Talk about it's actually, it's been a long time. Cross-examining the medical examiner. Arguing about 5'9", 5'11". The doctor, in his report, in his measurement, says that the victim, Charles McCormick, by the way, that's his address where all their cell phones are taken. medical officer says it, and the video shows that the shooter was bigger, lighter, and taller. I wouldn't call it an insignificant amount, which perfectly matches the way Hakeem Robinson looked the day before, weeks before. Remember, this is the defendant next to Leroy Whitaker. You've had the opportunity to see them. Not a huge difference, is there? And we know that Leroy Whitaker is smaller than the victim. 3 minutes or so, we heard about it. The video proves our case. Now, of course, no one's asking you to look at that video and find the defendant guilty beyond a reasonable doubt. We're giving you so much more. Got a couple rules that Mr. Robinson or any aspiring young rapper should live by. If you're gonna brag or post about killing somebody, you probably shouldn't have DNA in the murder car or a fingerprint on the gun left behind in the murder car. If you're gonna post hoodie pictures of yourself singing and rapping in the weeks and months before and after, you probably shouldn't wear the black and tan hoodie to commit the murder. If you're gonna have a burner phone, you probably shouldn't take selfies on it. If you're gonna stake out a victim, you probably shouldn't get distracted and let him leave his apartment complex, so you have to follow him to a Merrill Road strip center where police officers are hanging out. And if you're going to pick co-defendants to do the case with, you probably should have done it alone. If you're going to get picked up by the girlfriend of one of your buddies, you probably should hope that she's ride or die, that she's not going to come to this court with no intimidation, with no cases hanging over her at the time she gave her sworn statement and here today, and say, that's who I picked up. And just for a second, before you think, well, maybe Hakeem Robinson, he's too smart to do that. Whoever did this killing, it includes Whitaker and Barner, they decided to go in broad daylight in a neighborhood, jump out and run through a strip mall, execute a human being for the whole world to see. The actions of a 21-year-old that gets excited and angry because he sees a person that has so disrespected his brother. Has dared utter these words.
Smoking on Whitley, Parker screaming up for help. Headshot instantly.
Put it in your blood. Should we be smoking on with it? Picture to the left, rest in peace, brother, is posted less than 24 hours after the defendant took care of the person that spoke on Willie. There are very few people in the world, not exclusively this defendant, we've arrested a lot of them. A lot of them are charged, not all. A lot of them are charged. And there are others out there, but there aren't that many in ATK that had a motive to kill 6-block Little Buck. The greatest motive was Abdul Jr. defendants, Leroy Whitaker, and mind you, we tried these two cases together. All the evidence against Whitaker corroborates what Barner says, what the entire investigation leads to, and all of that evidence helps prove Robinson did. That's why we tried them together. So while you're not deciding Whitaker's case, you're going to have to know some of that evidence to know why Hakeem Robinson is guilty. And some of that is the phone records. But we have the opportunity by both defendants. Barner's admitted it. The opportunity by both defendants. Either the cell site is off or it puts them there. The defendant, by the defense's own admission, his known cell phone. Known cell phone. And, 21 years old. Want to get the times right. He has his cell phone powered off for the exact amount of time it takes to do this case, to do this crime. And his cousin and friend, overwhelming evidence, also overwhelming on him, when they're doing this crime. It just happens to be powered off. And the defense, I submit to you, was trying to show that the data on the phone, because you see there it's data, and this is the situation where the FBI analyst was unwilling to map the data sessions. Between those two times, nothing going on while his phone's turned up. Remember the cross-examination of the expert over and over again? He was on a boat. He was, no, your smartphone is on. It's getting data. Even if it's not connecting to a tower, it'll show data usage. Said that. They've kind of followed that. But when we plotted the data usage, which the FBI was unwilling to do on their own because of the errors, 95% accurate, I think 95 to 98% accurate. You know what that data usage, so this is when we did the Google Maps stuff, we put in the coordinates. When we did that, his known phone, his admitted phone, was in two really important places before it got powered down. Remember those Google Earth pictures? It was one picking up Barner off of University, Spring Park. We saw that map. Then it was off Atlantic Boulevard, which is exactly what Dominic Barner said they went to pick up the Impala. Excuse me, the Nissan, to commit this crime. In an apartment complex off Atlantic Boulevard. His phone, known phone, was in those two locations, just like Barner said. And those were never mapped. Barner couldn't have been fed the information by the state. Lo and behold, just like he said, like Barner said. So the other phone records show that you can see the red is going to be Mr. Robinson's burner phone, the phone that he takes selfies on, that Hakeem Robinson got in his dead friend's name that he handed him, that existed for about 2 months. On this particular occasion, Mr. Robinson thought that burner phone would never be tied to him because his real phone was turned off. And by the way, the whole selfie thing, and he never said, dads don't call their sons on their burner phones. Dads call their sons on their real phones. The burner phone is when you do dirt. So, he's hitting off the Merrill Road Tower shortly before the crime. The arrow points that he is going in the vicinity of Townsend Boulevard. This is you see the arrows, the red arrows, and then the 7201 Arlington, and the defendant's burner phone is going in those directions, and you can see the data usage in the green box to the right of all the little arrows. He is going in the direction of where he is picked up. This is his burner phone. His real phone is turned off. And then we find but it's going in the right direction. We find the cache. He deleted all this, by the way, but this was found in the cache. He didn't know about that. Off the burner phone cloud, phone's gone. On the burner phone cloud, we find the pin drop in the location of the nature preserve. You kind of see it cut off, the nature preserve, the tree hill on the right side. That is just, I don't know, maybe 100 yards, Lillian Road, Lone Star. That's just a little bit north of where he was picked up by Natalie Gann. Not the exact location, it's just a little bit north. We have the path he came through the tree hill. A nature preserve, where we're not at Boston, identified a person in a black and tan sweatsuit. Just the unluckiest man on the face of the earth. Identifies a black and tan sweatsuit coming out of the woods. I think he's a nature lover. And then Natalie Gann picks him up. Says a white girl carrying a phone. Mention the IP address. The defense makes a big deal about Smith not being an expert because the IP address helps prove that the burner phone is Hakeem Robinson's burner phone because of the IP address. The T-Mobile records, some of which you'll have in there, if you care to look at it, actually in some of the instructions, not all, but in some of the instructions in the records, the top line says the IP address, only the first four numbers should be considered. Now, the records that we have introduced in this case tell you it's just the first four numbers, not just Smith. That's just a side note. So we have them all together, meaning back safe on Brown Jersey Court, Hakeem, Kareem, and Barner, and Whitaker. Look at that. And this is, magically, the defendant's real phone turns back on when they're safe. Objective known truths. We know that Nissan is the murder car. We know the shooter fled with the murder weapon. Described perfectly. There is no murder weapon in the car. The murderer fled with the murder weapon. We know this as an absolute fact. Robinson is linked to the murder car in 3 different ways. Shirt, the driver's compartment swab, and the print on the firearm. Here's where the defendant, mind you, they spent 2 minutes talking about the DNA because it's not good for their case. I get it. But here's where their argument about transfer fails. Look at the way that shirt is. Hold on. Think back to what the DNA analyst said. I took swabs of the wearer, the neck, and the underarm. Not just in the middle of the shirt that's balled up in between the seat. Somehow, their argument is that this balled up shirt, wrapped up shirt that has wearer DNA of the defendant, oh, by the way, and Leroy Whitaker, of the defendant, somehow that jumped off of the shirt and got in the driver's compartment and is balled up in the corner of the seat. Maybe he's the unluckiest person on the face of the earth. Maybe he's just guilty. Oh, and there's prints on the slide of the firearm. It's right next to the shirt that has his and Leroy Whitaker's DNA. Maybe you shouldn't be bragging about killing Willie with that evidence. I mean, killing Willie's killer. Bragged about killing Willie. Incredibly powerful evidence. No chance that could be tampered with. Remember, they sealed the vehicle. It's the way it was when all 3 of them jumped out because they decided to commit a murder right in front of the police. And we were able to catch them. Whitaker's in the car 2 ways. He's on both shirts. We have those shirts. Robinson possessed a similar and unique firearm before the crime. This was kind of just glossed over. But we did pay a lot of money. And in addition to this defendant deserving that, digital expert Latham provided another service. Firearm in this defendant's hand just a few weeks before this murder. And he is celebrating it on the Bang It Up music video. Is the same type of firearm. And according to Barner's testimony, is the same one. We hear from the FDLE firearms expert, Emily Amahir, right? The first FDLE person we called. The manufacturer of that firearm discontinued. And although there are other models like it, there aren't that many of them. This isn't a Glock 9mm. This is some common firearm that everyone in the world has. This is a relatively, I don't want to oversell it, I'm sure there's guns out there. This is a relatively unique firearm.
Objection, Your Honor, mischaracterization of the testimony.
Overruled.
You rely upon what the expert, Ms. Amherst, said. No longer manufacture that kind of gun. Companies go out of business. It's usually because you don't sell a lot of the gun. Sell a lot of the gun, you usually keep making them, right? AR-15 is real popular. Keep selling them. Okay. Enough on that. Barner and Whitaker were so desperate to get away that they assaulted Miss Buckley and left their DNA on her pajamas. Again, it shows that they were all in for a penny, in for a pound. And that proof corroborates Barner, corroborates Blue, who picked up these two guys after they assaulted Miss Buckley. And you heard all that testimony. And with the buttons here and not here. Whitaker and Barner got picked up by Blue. We know that that's a fact. And they pled. Y'all have already, these are objective truths. You don't need to assess credibility here. Robinson is right-handed. Fact. Shooter was, guess what? Right-handed. Does that prove he did it? No, but it's a nice fact to know, isn't it? He was worn, and he has worn a black and gray hoodie just like the shooter has worn. When you combine all of these things, you are narrowing the scope beyond just the exclusion of every reason. We are not eliminating every conceivable possibility. We are not eliminating all of them. I said it to you, we have. But the proof here is beyond to the exclusion of every logical, well-founded, reasonable doubt that any logical person could have about whether we got the right guy. Robinson was real happy. Defense wants you to think that he's arrested because of this post. Sergeant Smith has his fingerprint on a pistol in the driver's seat console, like in between the seat and the console. With his print on the slide.
Okay.
It's in between the seat and the console. He has his print. And that's the post he sees. It's context. You know, they said, we're going to explain the context of all that. That's the context. Context is, Smith goes, holy cow, the guy's bragging about it. The kind of person that would brag about this is the same person that would go out, narrow road, at 10:58, and gun down another human being in front of everyone in the world and the dash cam to see. Same type of person. The video proves the descriptions were wrong. We called the witnesses that were able to provide meaningful testimony, not the witnesses that were working out on the elliptical or looking through glass. For them to say, I guessed, none of them were sure. I guessed about the person, and the video proves me wrong. Spent a little bit of time talking about Barner. He is a murderer. I don't like him. Vince has a good time. He got beat up twice by two very seasoned, experienced defense lawyers. It's hard to sit there and listen to them beat him up. Fine. We expected that because he deserves it. Reprehensible deal. They turned around and screamed at the state of Florida for that. We got a convicted murderer to subject himself willingly to his own free will. Have Judge Salvador sentence him to life without the possibility of parole. The only benefit that we gave him is you get to testify, show your remorse, stare at the face of your community, of your friend, and do what's right in Charles Court. If you do that, the judge can consider it anything she wants, including giving you life. 45 years. He knows that. There's nothing he can do about it. I wish all prosecutors were that unsuccessful in convicting murderers. Lou is looking at 20 years. He's a middle-aged, 50-something-year-old guy, 55 I think he is, with diabetes and kidney failure. Not very different from the deal worked out for Barner. All witnesses meet. It is entirely proper for witnesses to meet with us. The defense wants to say, well, I'm not going to argue they shouldn't meet with their witnesses, but they shouldn't meet with their witnesses unrecorded. Scenario. Dominique Barner, you're going to plead guilty and subject yourself to life. The lawyer is here. We need to make sure this is something that you really want to do, because once you give this sworn statement, there's no going back, because you're going to be under oath. We're going to sit down and make sure that this is something that you're going to be willing to do before we go on the record. You're staring at your friends, your community, your family, and you're turning into the one thing that you swore you would never be. Snitch. Are you sure you want to do this? Yeah? Is this what you're going to testify to? Yeah? All right, we're on the record and we're putting you under oath. Oh, how dare the government do this? A pre-meeting is somehow evil? This is what they're arguing. No witness should be discredited for talking to a lawyer about his or her testimony. Barner wants the absolute best deal for himself. No doubt about that. He said it over and over again. So his plan, according to the defense, is to lie to the people who will recommend a sentence to the judge and lie in front of the judge that's going to sentence him. What if over years and years we find out that he's lying to us about the facts of the case? Remember the DNA evidence didn't come back? It was until mid-2022. All that cell phone, all that Instagram, that stuff's just pouring in. And we're going through it up until shortly before trial we're pouring through it. And somehow he's going to make the decision, I'm going to subject myself to life, knowing she can give me life, knowing the state will make a recommendation, I'm going to lie to these people about who's with me? The defense challenged me to say, why on earth did they say that part of the deal was I had to implicate my son or my good friend? And they said, yeah, if I say it's somebody else, the deal's not there. Because it's the truth. And if they say somebody else besides the person that did it, then of course there's no deal. Because they're committing perjury. The evidence doesn't show anybody else. The one little piece of evidence that shows somebody else, sort of, is this Chris guy whose hair, not skin cells or blood or anything like that, whose hair, which is much more easily transferable, and he lived and hung out with the people living in that Brown Jersey courthouse. I don't know if he lived there, but he certainly was there. The testimony from Abdul Robinson was he was there all the time, and his baby mama lived there. But he was there all the time, and that little piece of hair was there. So what did the detective do? Pull his cell phone records. Let's see where this guy is, even though there's no implication he's an ATK or any of that stuff, or has any motive to do any of this. But they go pull it, he's across town. You know, one of the jurors said in jury selection, trust but verify. And that is exactly what you have seen here today. You don't have to trust every word Dominique Barner says unless you verify it. Even the defense had to admit. If you caught me smirking, it was when I heard this. The defense had to admit that Barner got his facts straight. Yeah, he did. He gets his facts straight. Trust, but verify. Barner had no idea the person he said that picked him up was going to testify and agree to that. He didn't know that when he gave his sworn statement. How was he supposed to know that? Barner doesn't know that Natalie Gatton and Nada Boston were here to testify. I need to reset here because the video evidence that we had in our first slide, it shows how the defendant looked leading up to this crime, combined with him wearing the sweatsuit and then the picture of the shooter. That piece of evidence, combined with Nada Boston and Natalie Gatton, you don't need DNA, you don't need Barner. That evidence in and of itself is enough to convince any reasonable jury that we got it right. So when you combine all the pieces of evidence, we have a guy in a black and tan hoodie murdering Charles McCormick, running into the murder car, jumping out of the murder car with the same gun, running and jumping fences. And by the way, thanks for the video when you toggled. I'm not talk about that much more. I appreciate it. We did it. It certainly seems like the police officer is a little bit taller than he should be. Anyway, jumping fences, doing all those things. One more thing, got the sprinting. You see the video, we played a little bit of it. And God bless police officers who chase after gunfire. I have to put on a bulletproof vest to go to work. But he was coming out of Publix off duty. Whole body cam thing. He's not prepared to work that day. He's off duty.
Objection, mischaracterization of testimony, he was on duty.
Overruled.
That's besides the point. You remember, it's not my anything. Does it really matter? That he was so cautious when he was looking for me to walk out of that car. Then he sprinted out of the car. Officer Collins walked kind of slowly, looking around because he knows, he said, someone could be sitting there ready to ambush him and he saw that guy with a rifle. He wasn't chasing after him full bore. That's idiotic. That's how he got away. Nada Boston says, after I get a text alert, it takes a long time to get where the defendant got all the way through that woods to get rid of the burner phone and the rifle. To get rid of those things. He comes out of the woods wearing a hoodie by himself. She goes, I'm getting out of here. I did notice a girl, white girl with a phone. Let's be very, very clear about this. Natalie Gann came in, sworn statement. She was a free woman. Everyone she loved and cared about. Her husband getting arrested subsequently is irrelevant. She'd already given her sworn statement. These are not people, as the defense characterizes, coming in chains by the state's leash. All the eyelash comments the defense can make about her doesn't change the fact that she was a rock on that witness stand. She said, I used to date Torgon. I know all these guys. They weren't going to go up there and pick this guy up. They told me, the white girl, pick up this guy. I don't know if you pick up this guy. If we're trying to strong arm her to testify, why doesn't she say he was wearing a black and tan hoodie? As opposed to the truth, which is, I don't remember what he was wearing, but it was a king. That's where the not a Boston combination with Natalie Gann is proof beyond a reasonable doubt. That's the identity of the person that executed Charles. Forget the DNA, forget the prints, forget the brand, forget Barlow, forget Blue. Combine it all. That's where you get beyond a reasonable doubt. You have that abiding conviction of guilt. You can be confident in your verdict. And that's where we get beyond all possible doubt. Dominic Barner may be a liar. He's not lying. Couldn't know the digital expert Latham was going to analyze the body morphology and conclude the defendant could be the person behind the mask. Now, how did he know that? No idea. And by the way, you have to combine that with the knowledge Dominic Barner has given his life over Judge Salvador in the state of Florida as the defense capacity. He's given his life over to us. He better be right when he tells us who did this. Because the body morphology will prove it. Lying. He won. Barner had no idea that we would be able to link Whitaker's phone on Instagram. Instagram for Whitaker is the verification number on his Instagram records. And when he on Instagram says, this is my phone number, ding, 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 we were able to link it to Whitaker. You know, it's not registered to him, but he says, this is my number on Instagram. And it proves, that phone proves the location every single step of the way that Whitaker is at with Barner. Step in for a penny, in for a pound. And Barner had no idea that the cloud would capture proof of Robinson's burner phone was his, and they could link him to the murder. He had no idea of he couldn't fabricate the DNA and print evidence. He did not know that Robinson's known cell phone was turned off during the murder, that the phone data of the known phone would be feeding off his apartment and the pickup for the Nissan. Well, how does he know that? Look how street smart you are. It's going to be hard for y'all. It was hard for us. Mr. Cooper and Mr. Atkinson are much better at it than I am. I struggle with this stuff. And Dominic Barner's going to do it? It just means he's telling the truth. That's all it means. The defense challenged the state on a number of different things, and each and every one of those we have easily rebutted. Out of Boston never said shoulder length dreads. She said dreads to the chin, which if it's sticking out of a hoodie, that's about where it is. Defense argues things like, I'm not saying that Chris Brown did it. Look at the video, you'll see the defendant's hand. You'll see Hakeem Robinson's hand and compare that to his complexion. It's insane. Not to mention all the body parts. There is no DNA transfer. The defendant was in that car, jumped over the center console, which is where his touch DNA came from. And the shirts and the guns that he'd already handled. Jumped out and was so excited, he didn't wait for his backup. $700 billion to 1 chance that someone other than the defendant is on that shirt. 4.4 million to 1 chance that this defendant's touch DNA is on the driver's area. He's either the unluckiest man on the face of the earth. Just plain. No matter how many times you pound on the table, scream 6'3", 230. Have the video evidence to prove it's just not true. And then, once you know you have that abiding conviction of guilt, the job is yours to find the truth in this case. The dead, they can't call out for justice. It's up to us, the living, to seek it on their behalf. Nothing that we do here change the lives of that poor family. He will be dead forever. And the last known photograph of him will be on the slab in the medical examiner's office. But what your verdict can do is forever define Ksoo Robinson is the man behind the mask. Proven to you 700 billion. Trust that you will uphold your duty to find this defendant.
All right, thank you, Mr. Mizrahi. All right, members of the jury, you have now heard and seen all the evidence which will be introduced in this case, and you have now listened carefully to the arguments of the attorneys. And I'm now going to direct your attention to the jury instructions, which I'm required to give you, which I remind you, you are required to follow. For your convenience, the jury instructions are going to appear on the monitors before you so that you can easily follow along as I read them to you. In addition, I'm going to be sending in one hard copy of the instructions to the jury room for your use during deliberations. So let's make sure that your monitors are on and working. Yes? All right, very good. All right, let us begin. And I would ask any members of the gallery, if you wish to leave now, you may do so, but once the instructions begin, I don't want people coming in or out, that would cause a distraction, excuse me. All right. Thank you. All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Hakeem Robinson has been accused of the crime of murder in the first degree. In this case, Hakeem Robinson has been accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. I now instruct you on the circumstances that must be proved before Hakeem Robinson may be found guilty of murder in the first degree or any lesser included crime. As to count one, to prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Charles McCormick Jr. is dead. Number two, the death was caused by the criminal act of Hakeem Robinson. Number three, there was a premeditated killing of Charles McCormick Jr. by Hakeem Robinson. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. As to count 1, to prove the lesser included crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Charles McCormick Jr. is dead. Number 2, the death was caused by the criminal act of Hakeem Robinson. Number 3, there was an unlawful killing of Charles McCormick Jr. by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and number 2, is done from ill will, hatred, spite, or an evil intent. And number 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. As to count 1, to prove the lesser included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Charles McCormick Jr. is dead. Number 2, Hakeem Robinson intentionally committed an act or acts that caused the death of Charles McCormick Jr. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. The state must prove the crime was committed on January 15 of 2020. It must be proved only to a reasonable certainty that the alleged crime was committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Number six, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number seven, has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number eight, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Number nine, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or has been promised immunity from prosecution or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Now, these are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Number 8, your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, during this trial, I have permitted you to take notes. You will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid your individual memory. You should not compare your notes with the notes of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. They are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And it will be on the screen, but I'm also holding in my hand the one-page verdict that is styled State of Florida versus Hakeem Robinson, titled Verdict Count 1. You have 4 verdict options, and they read as follows. The first one is, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. If that is your unanimous verdict, you mark that line with an X or a check. The second verdict option reads, we, the jury, find the defendant guilty of second-degree murder, a lesser included offense. If that is your unanimous verdict, you mark that line. The third option reads, we, the jury, find the defendant guilty of manslaughter, a lesser included offense. If that is your unanimous verdict, you would mark that line. And we, the jury, find the defendant not guilty. If that is your unanimous verdict, you would mark that line. So say we all, done at Jacksonville, Duval County, Florida, and there's a line for the foreperson to sign and date the verdict form. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring that verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or any electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. And if you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, either in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So, ladies and gentlemen, that will conclude the instructions. At this time, I will allow you to take your notes, 1 hard copy of these instructions, the verdict form, and all of the exhibits into evidence back into the jury room for you all to begin your deliberations. And as we discussed yesterday, this will be a working lunch. Of course, you can eat lunch in the jury room. And that will be all of you, with the exception of jurors number 13 and 14. I don't know, ladies, if you all knew that you were the alternates in this case. We generally don't share that information with our jurors prior to this point, but that means you will not be deliberating with the rest of the jurors in this matter. Now, before I excuse you, do you have any personal items that you need to retrieve from the jury room? Okay, if you both could quickly go with the bailiff to retrieve those things, come back out here as I'll have some final parting instructions for you. And the rest of you, ladies and gentlemen, if you don't mind just patiently waiting until they return. You may go now. Kim, you staple that for me. All right, you all may have a seat. And so, ladies and gentlemen, while we wait for the alternates to come, just some other tips or instructions. As you've seen in the jury room, there's a large television, smart television, and that's the device you would use to either watch any videos or hear any calls with discs that have been moved into evidence. Should you experience any IT difficulties, we are not expecting that you will, but should there be any technological issues with the use of that device, you can please ring your buzzer and send a note through the bailiff, and we will be sure to get whatever issues fixed. But otherwise, you can take your notes. We will transfer in all of the exhibits into the jury room, and then you may begin your deliberations. We'll just await the return of the 2 alternates. All right, thank you. All right, ladies, if you don't mind just standing here to the side so we can let the jurors leave, and then I'll just have some final instructions for you. At this time, ladies and gentlemen of the jury, you may now retire to the jury room to deliberate your verdict. All right, the jury's out of the courtroom. Ladies, I want to thank you so much for your time, your attention, your service during these 2 weeks of trial. I'm sorry, I need to look at y'all. Let them close the door. I know this has been a huge ask. That we make of our jurors, that we make of our community members, and I hope you don't feel like your time has been wasted. Alternates play a very important role, and we oftentimes have to use them in the deliberation of cases because we, especially on multi-day or multi-week trials such as this one, we lose members of the jury for a variety of reasons. Illness, health, emergencies. I mean, as you can see during the course of this case, we've lost some members from both panels for a variety of reasons. And so when that happens, if we did not have alternates, we would not be able to proceed with the case and there would have to be a mistrial declared. So it is a very important role you serve, and I do sincerely and genuinely thank you for your service. At this point, I will tell you all of my prior admonitions and prohibitions about talking about the case with anyone or looking things up or watching on the news. Those are all lifted. You are free to do those things if you wish. Absolutely no prohibitions against that. I will also tell you that you might be questioned by folks who are simply curious about your thoughts and opinions on the case, by the media, by the attorneys, by anyone. And so the decision about whether or not to maintain your privacy, of course, is yours. You do not have to speak to anyone. Of course, you're free to do so if you wish, but otherwise you are free to leave and not to speak to anyone here. Now, if you want to stay to see what the verdict might be, or if you want to leave but still know what the verdict might be, we have your number. We can certainly call you and let you know. But at this juncture, ladies, with the court's sincerest thanks and appreciation, you are now excused and free to go. All right, thank you. Yeah, you can send everything. Mm-hmm. Except the live rounds. Yeah. All right, the alternates have left the courtroom. Any exceptions or objections to the jury instructions?
Not by the defense.
Okay. I will let you all know that I've received word that the Whitaker jury has reached a verdict. That happened at approximately 11:42. Obviously, they needed to wait until this part of the trial finished. So it is now 12:27. Just need the door to close. Okay. So with that, I'm happy to hear from the state or the defense from Mr. Whitaker what you all want to do. I know you briefly discussed sealing it yesterday. I don't know if that is necessary at this juncture. I don't necessarily want to keep them here waiting for hours.
I know that's a problem with the jury. The concern that the state,
Okay.
the concern that the state has is, obviously I expressed it last night, that if they immediately, publish that verdict everywhere. If this jury is unable to reach a verdict before they are excused for the night, which I assume that the jury, the judge, Your Honor, will keep the jury late.
Yep.
Not, obviously, the richest one they can't stay anymore. So that's the only concern. I think we've given the jury the case early enough to have some level of confidence that that's not going to happen. And certainly, if it does, the worst case scenario happens, stronger admonitions about lack of contact, no chances on it.
Okay.
That is a concern. We discussed it yesterday. I'm not really sure. I understand not keeping them for 6 hours twiddling their thumbs.
Right. And obviously, Mr. Robinson's jury just went out here at 12:24, so we still have a good chunk of the day left. So that does give me also some confidence if it's 8 p.m. and they haven't reached a verdict, or 9 p.m. and they haven't reached a verdict, then I suppose we can address what to do at that juncture. But otherwise, Ms. Schlax, any issue with my releasing the verdict at this time?
In consultation with my client, he is requesting for it to be sealed.
And why is that? Okay, I understand the request. Also, quite frankly, I will say, since this case has generated a lot of interest and we have had full and crowded courtrooms, doing 2 verdicts at once might pose some issues that maybe wouldn't be present if we did them separately. So that's another reason that I think my preference, unless I hear strong legal basis or arguments otherwise, is that we're going to receive Mr. Whitaker's verdict now.
Your Honor, my concerns are I don't know how insulated that would, if anything, is heard. The other suggestion, a thought that popped into my mind, would release the Whitaker jury as if they had gone a full day and still needed it and call it back at a point in time to read the verdict.
But I wouldn't know at what point in time, and then trying to get them back from different parts around Jacksonville, that doesn't seem doable. And in terms of them hearing, usually it's Madam Clerk who publishes it. She does not have to speak into the microphone, and I'm pretty confident that it would not be heard in there.
Can we put them in that other jury room?
Well, they're in that jury room now.
I'm saying that once they're brought in, to put that jury into that jury room. Again,
Yeah, that would be a telltale sign that that jury has reached a verdict and they're not there anymore, so.
just as long, I mean, if it's 100% that they wouldn't hear anything.
Yeah, we don't have to speak into the microphones. We can announce it right here.
Is there another courtroom where it could be read?
I mean, we have lots of courtrooms in this courthouse. I don't know if,
Just throwing out options.
yeah, no, I don't think that's going to work at the moment. This is the only one that is now fashioned with that Thor camera on the back of the courtroom, so then that brings in a whole host of other issues that we cannot on the fly change at this juncture. We can not speak into the microphones. Nothing is heard in there if nothing is amplified out here.
And with that, Judge, of course, understanding that this is an extremely serious case for both sides, you know, and I understand that the gallery on both sides may have a...
Oh, believe you me, I'm about to give an admonition about that. So if y'all want to take a seat. All right, so ladies and gentlemen, we are now going to receive the verdict in the Leroy Whitaker case. I cannot stress this enough for everyone gathered here on both sides of the gallery. There shall be absolutely no emotional outbursts of any kind, regardless of what the verdict might be. If you think in your hearts that you cannot control your emotions or your voice, then I ask you now to leave this courtroom. Otherwise, you are welcome to stay, but I don't want to hear one peep out of anybody in the audience. Does everyone understand? Answer aloud.
Yes.
Is there anyone who doesn't understand? Please raise your hand. All right, and I see no hands raised. All right, you jeopardize the other case and the other trial if you do. So no emotional outbursts. I don't think I can be any more clear. All right, do you want to switch tables and have Mr. Whitaker and Ms. Schlax on the front table? All right, if both sides are ready, then let's bring in Mr. Whitaker's jury. Do I hand it to you to read? So that Phil face this way and not be too loud. Yes, ma'am.
Jury's in the courtroom.
All right, thank you, ladies and gentlemen. You may take your seats. And juror number 3, you're 5, yes. Has this jury reached a verdict? Can you please hand the verdict form over to the bailiff? All right, the court finds that there are no errors or omissions in the filling out of the verdict forms. Madam Clerk, can you please publish each verdict?
In the Circuit Court of the 4th Judicial Circuit in Fort Duval County, Florida, case number 16-2020, CF 36018, Division DRE, Salem Court versus Leroy Whitaker Jr., as to count 1. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment, so City Hall, Town of Jacksonville, Duval County, Florida, Town of Fort Worth, State, dated July 31st, 2025. Verdict as to count 2. We, the jury, find the defendant guilty of charged in the indictment. We, the jury, further find the defendant committed or battery during the course of the burglary. So said the all for the Jacksonville, Duval County, 4% dated July 31st, 2025.
Does counsel for either the state or the defense desire the jury to be polled?
Yes, Your Honor.
All right, Madam Clerk, if you'll please poll each juror.
Yes, ma'am. Jury number 1 is issued to a correct verdict. Jury number 2 is issued to a correct verdict. Jury number 3 is issued to a correct verdict.
He's number 5.
Sorry. Jury number 5 is issued to a correct verdict. Jury number 6 is issued to a correct verdict. Jury number 7 is issued to a correct verdict. Jury number 8 is issued to a correct verdict. Jury number 9 is issued to a correct verdict. Jury number 10 is issued to a correct verdict. Jury number 11 is issued to a correct verdict. Jury number 12 is issued to a correct verdict. Jury number 13 is issued to a correct verdict. Yes. And jury number 14 is issued to a correct verdict.
All right, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in that jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. And we have recognized for hundreds of years that a jury's deliberations, discussions, and its votes should remain its private affair as long as you wish it. Therefore, the law gives you this unique privilege not to speak about the jury's work. Although you are now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, or from the media, or from the attorneys, or elsewhere. So it will be up to you to decide whether to preserve your privacy as a juror. And with the rendering of these verdicts, your service here in the Duval County Courthouse over these past 2 weeks is now concluded. and I wish to thank you again for answering your summons last Monday, coming down to the courthouse to be part of the administration of justice. All of my prior admonitions and prohibitions that I've imposed upon you about talking to people, about looking things up, about seeing, reading, or hearing anything in the news media or social media, those are all now lifted. You are free to do those things if you wish. But I wish to genuinely and sincerely thank you for your time, your attention, and your service, despite our fits and starts and sometimes delays that has allowed us to conclude this matter here with you today. So again, many, many thanks. I will let you go with the bailiff, where you will then be able to retrieve your electronic devices, your personal items, again with this court's sincerest thanks and appreciation for your service. You are now excused and free to go.
All right, y'all, there you have it.
All right, counsel, please
Oh, wait a
present your
minute.
client before the bench. All right, Mr. Whitaker, based upon the verdicts of the jury finding you guilty of these 2 counts as charged in the indictment in case 2020 CF 3601, the court will now hereby remand you to the custody of the Jacksonville Sheriff's Office. Any bonds previously set shall now be revoked. And is he entitled to a pre-sentence investigation report, Ms. Schlacks?
Yes, Your Honor.
Okay, then I will order the preparation of a pre-sentence investigation report prior to sentencing, and that does take approximately 30 days to prepare. So when do the parties want to come back for sentencing to be set? I have available, of course, any week 30 days from now would be end of August, so either the week of August 25th or the shorter week of September 2, Monday being a holiday.
Your Honor, if we could do the 8th, September 8th.
September
Monday,
8th?
to be set. I'm out of town.
Okay, does that work?
Yes.
All right, then we'll set this matter for Monday, September 8th for sentencing to be set. All right, that is it for Mr. Whitaker for today. Thank you. All right, then as to Mr. Robinson's jury, counsel, just be sure to leave your cell numbers with Madam Clerk so that if the jury has any questions or a verdict, we can easily and quickly reach you to return back to courtroom 407. If there is nothing else, anything from the state?
No.
Anything from Mr. Robinson?
No, Your Honor.
Okay, then we shall be in recess.
All right, so there you have it. If you missed part of the day, we started out with she charged Scotty's jury at 9 a.m. So when we first got on her, Scotty's jury got the jury instructions and they were sent back. Ksoo was brought out. His attorney started with his closing argument. The state rebutted, and then she read the jury instructions to Ksoo jury and sent them back. In the amount of time that it took for all of that to happen, Scotty's jury got a verdict. They came right back into the courtroom and found him guilty on all charges. He's been remanded, which means he's going to stay in jail. And he is going to be sentenced on September the 8th. All right, Scotty's looking at life in prison. He's looking at life in prison for his crime. So I can't tell you what each charge is, but it is essentially life in prison that he's going to get. Shout out to Flesh of the Gods. His crew has come over. So everybody from the Telegang, make sure you welcome Flesh of the Gods crew in the building. And so that's kind of where we are today. So we are pretty much on verdict watch. No, Scotty did not have a public defender. And honestly, The evidence against Scotty was damning. There, I didn't see him getting out of this at all. The DNA sealed the deal for him. I think they could have argued the car. They could have argued the way, they could have argued they could have argued the, the DNA inside of the car, but the DNA on Barbara, the DNA on Barbara sealed the deal. He was absolutely there, absolutely got out of that car and ran. Even if you don't take Butter's testimony, because I don't consider Butter's testimony, to be honest. I think he's a liar. But even if you don't take Butter's testimony and you just look at the evidence, that DNA pretty much sealed the deal for Scotty. All right. These guys are young, so they gotta be in their mid-20s now. I think Ksoo was like 21 when this occurred. So he's looking up to a life sentence, y'all. Sorry, I'm trying to hit some of y'all comments. But Scotty had a paid lawyer. He did not have a public defender, and she did a good job. I'm not even gonna lie. She did a damn good job attempting to throw in some reasonable doubt. She did what she was supposed to do, but when you got bad facts, ain't really nothing you can do about that. It ain't nothing you can do to run from them bad facts. And I think that's what the attorneys on Ksoo's side did as well. They had bad facts, and I don't feel like they refuted those facts well enough. But when you look at that cell phone and that cell phone data, I think it puts them in the car, and they don't really have to prove that he is the shooter. All they have to do is put him in a car. All they got to do is put him in a car. They didn't really have any answers for him being picked up. He had no alibi to be over in that apartment. I don't know. The reasonable doubt does come in with the descriptions, because you can't say somebody is one foot tall this day and another foot tall another day. Like that's a huge discrepancy, but he doesn't have to have the gun in his hand to be found guilty. All they got to do is put him in a car. That's it. And even his DNA being in the car, they had that car since November of 2019. This happened in 2020. So the car had been stolen since November of 2019. So that was plenty of time for young YNs to be doing YN stuff in a hot car, right? Nobody is saying that he probably wasn't riding around in a hot car. So they could have definitely argued that, and I think that they did, or at least they tried to. So the DNA in the car didn't necessarily prove anything, in my opinion. You think they told Ksoo about Scotty? Oh, they most definitely, they walking past each other. They walk in the holding. They walking past each other. I think he know. Wait, what are the charges for Scotty? Scotty got second-degree murder, and he also had a home invasion, burglary and assault. So the Hummingbird testified against him and gets 20 and walk. Well, he don't know what he's getting. He's hoping to get 20 with paroling out in 6 years, but I guess we're gonna have to follow up and see what the sperm donor gets. 19-year-old set up by two grown men. I think he should have gotten an accessory after the fact. I am speaking. Ksoo is probably in the room. Scotty is his co-defendant. So this is a critical stage of both of their trials. Yeah. He might be. I didn't hear them say that they took him out, so he could be sitting there. But if he didn't, then there's a holding area in the back of the courtroom that I'm sure they kind of walk past each other, or, Let's see. Fulio would have had a field day with this. Well, his trial is getting ready to start. His murder trial is starting on August the 18th. In a couple of weeks, Alicia is going to trial, so make sure y'all check that trial out. It'll be aired as well. If he would have taken a stand, do you think it would have been a different outcome? I don't think they had answers. It would have not been smart to take the stand, Chantel. There was no way he could explain it. Blue getting out in less than a year, and he's getting witness protection. Well, that's a thought. I don't think so. I think that a reasonable judge, if he gets in front of a reasonable judge, is gonna slam him. Sparkle, are you covering it? I am not. I'm going to law school and I start on the 18th. So I won't be able to cover, I won't be able to stream it. But if I'm able, one of my friends is one of the attorneys. So I'm hoping to watch the trial and maybe produce some recaps. So if you have not subscribed to my channel, make sure that you hit the subscribe button. All right. Check out my shorts because I do be posting little shorts, little recaps as things come up. And I feel like we're at a transitional stage in our content because I'm about to start learning the law. So, you know, we kind of having a graduation moment here. So some of my content may change a little bit. It may come from a more legal perspective, but still stand true to who I am and being culturally inclined. So if that's something that you're interested in, make sure you subscribe to my channel. You're welcome. I've been saying this the only way Scotty was going to be good if he snitched on Ksoo, but his loyalty ran deep. It's the same judge. Oh, yeah. Well, Flesh, if it's Tati, I think Tati is not gonna hold back on them. Tati don't play them games. She gonna max him out. It looks like Blue is really over ATK, not Ace. I mean, it's just an interesting perspective, Blue in general, because as an older individual, the OG, quote unquote, like he had a history of pretty much telling. And I kind of feel like he might have orchestrated a lot of this, being in the car when the other guy was unalive, when Willie was unalive. Like Blue was deep down in the trenches with some kids and then turned around on them kids. So ain't no telling, Chantel, if he was really the leader or if he was just living out his childlike tendencies. Excuse me. Thank you, Tiffany. I appreciate that. It's 327 people in here with 88 likes. Come on, y'all. Y'all got to hit that thumbs up button. Hit that like button on our channel. Make sure we get our video pushed out there. Did Ksoo get found guilty? No. Ksoo's jury is deliberating. So we are on verdict watch for him. Blue been snitching since 1999. And you know what, Jason? That is what they said in their opening, too. They said he been telling since before Scotty was born, which is crazy. Do you think they will try and come after Ace? I don't really know too much about the ATK. I'm older, y'all, so I don't too much know about what Ace is involved in or the music, so I can't really say. I feel like at the end of the day, everyone did their dirt, including the ones who didn't get caught for stuff. Both sides was the reason why them people died, and their little boy was sad but wasn't innocent. I agree with that. Ksoo's verdict is not in yet. He was the head, but he was a rat. Oh, Lord. This is why the YNs don't respect these old. Well, you know, I can't speak on it, but the YNs is a different breed. They are a different type of individuals out here, boy. I'm not lying. I'm not lying. Also, I know y'all probably follow the YNW Melly trial. Melly is still set to go to court on September the 10th. So make sure y'all check out that trial as well. I think Ksoo's gonna be found guilty. Yes, that's just my opinion, though. I could be wrong. But he told on the police. Yeah, that's what they say. That's what they say. He told on the police. Feds coming. Listen to Ace music. He knows they're coming after getting in them phones. See, I can't listen to the music because it ain't PG-30. I need PG-30 music. I can't listen to the other stuff. It's too hard on my ears, you know. All right, Irvin says that he don't think he's gonna be guilty. Well, you know, to each its own. To each its own. I think so I kind of said this before, but I think that the evidence, the phone evidence, I think it sealed it for me. I don't think he was the shooter. I don't believe that he was the shooter. I think that Butter was the shooter, but I do not believe that he's innocent. For real. This was one of the best trials ever. Why do you say that, Chantel? You know, we've watched some very, very interesting trials over the course of the last year, honestly, from YSL to Tim Harrington, ASAP Rocky, Karen Reed. We watched a lot. Why do you think this one was the best? Yeah, the YN's always doing something. Why do you think he's gonna be found guilty? I think the phone data got him. I think they had a chance until their phone and being picked up by Natalie over there in those apartments. They didn't really have an answer to that. They didn't really rebut that, in my opinion. And I don't see, like, even if I try, I can't discredit Natalie. Like, I think Natalie was lying up there. I think she knew more than what she was saying, but I do think that she picked him up. Claudia, it got to be PG-13, y'all. I can't get with it. It got to be good. I think FBG Duck trial was the best, but we couldn't see the footage. And you know what, Chad? That was what hurt this trial for me a lot, is that we could not look at the evidence. I think that our perspectives would have been swayed by actually being able to see the videos and see the pictures and the things that they were comparing. I don't think we really got a good look at it. The only thing that they really showed us was the forensic video expert data, where he came in and was trying to, the guy they paid like $80,000 to, and he had like those video images, and he was trying to like determine the height of the shooter by digitally creating it and going out and taking pictures of the guys. And so that was the only thing we saw. And then I think we may have saw the dash cam from the truck too, but other than that, like, we didn't get to see a lot of what was shown, which sucks. Well, see, what my theory is, the shooter and the person in the back seat went in the same direction, and the driver went in the opposite direction. That's my theory. But you know, I could be wrong though, y'all. That's the beauty about trials. Everybody can form their own opinion based on the evidence. Max, you better leave that Chat GPT alone. They not already found that Scotty was guilty. He gone. All right, y'all. So we are pretty much on verdict watch. And so what that means is that I will keep this particular tab open, and I'll continue to listen to see if they come back live and tell us anything, if the jury has questions or whatever. But in the meantime, in between time, we're actually going to switch over to another case that we're watching. Oh, it looks like the jury is still deliberating over in the Ali trial. Wait a second. Actually, y'all, it's this new trial that's getting ready to start on Court TV. It's the Baby Left in Stranger's Yard leads to discovery of 4 bodies. So we might have to jump on over there and see what that's about. Yep. See y'all later. Like I said, we're gonna watch another trial. In the meantime, in between time, while we wait for a verdict to come back. Now these folks might be in there 2 hours, they might be in there 5 hours. It still takes them a couple days, so we don't know how long it's gonna be before they come back. Boy.
Not I heard 3.
Tell us the time that passed between each shot.
Como número 1,
Like, well, first there was 1
cuando desperté
when I woke up,
y cuando se fueron caminando para la gas,
and then when they went walking to the gas,
cuando me metí a la cocina,
when I went into the kitchen,
escuché otros 2.
I heard another 2.
How much time passed between the first shot and the second shot?
El primer disparo y el segundo disparo.
Unos 4 minutos posiblemente.
Perhaps 4 minutes.
Did you ever see any weapons at all on that day?
¿Ese día usted llegó a ver alguna arma?
No.
No.
Do you know who fired the shot that killed Cordarius Skelton?
¿Sabe usted quién
That's the person found in the grass.
disparó a una persona, al difunto, a Corderos?
No.
¿Está en el pasto? No.
Do you know who the 2 people were? Do you know who the 3 people were walking down the street toward the gas station?
Las 3 personas que estaban caminando en dirección de la gasolinera.
No.
No.
Do you know when Cordarius Skelton was shot?
I'm gonna object.
So don't answer the question yet.
Okay, no, the question would be, does he know Cordarius Skelton?
Do you know when anyone on that day was shot?
Porque llegó la policía, llegó SWAT,
Because the police arrived, SWAT.
y el detective me dijo de que había habido un accidente ahí.
And the detective told me that there had been an accident.
What else did the detective tell you?
Que le dijera lo que yo había visto.
To tell him what I had seen.
How many law enforcement officers were there when you were questioned on that day?
¿Cuántos oficiales del cuerpo policial estuvieron ahí cuando se le interrogó a usted ese día?
1.
1.
Were you speaking in English or Spanish?
¿Está usted hablando en inglés o en español?
En inglés.
In English.
Did you remember, do you recall whether the detective was wearing some type of recording device or camera on his body?
¿Se acuerda usted? ¿Podrá acordarse usted si es que el detective estaba diciendo algún tipo de cámara corporal, que portaba alguna cámara corporal?
No me di cuenta.
I did not notice anything like that.
Okay. And with regard to noticing, on February 5, 2024, is it correct that it was dark outside?
Y con respecto a darse cuenta de las cosas, ¿estaba oscuro en ese 2004?
Sí.
Yes.
So from 503 Chapel Road across the street to 516 Chapel Road, in the dark, no headlights, no illuminations from street lights. How are you seeing all of this?
Desde el 503 Chapel Road hasta el 516 Chapel Road, sin haber faros de carro, sin haber iluminación. ¿Cómo es que usted está viendo todo esto?
Porque hay una lámpara enfrente.
Because there's a light in front.
In front of what?
¿En frente de qué?
De la calle.
In front of the street.
Where on the street?
¿Dónde? Sobre la calle.
Alcanza a mirarse un poco.
You can see somewhat.
No completamente noche.
It's not completely nighttime.
So it's not pitch black, correct?
Entonces no está oscura 100%, ¿correcto?
No. Could you tell if the bodies, the three people, were male or female?
Podría darse cuenta si los cuerpos eran varones o hembras.
No, yo creo que por lo que miré eran hombres, pero no estoy seguro.
No, I couldn't tell. From what I could see, I could see that perhaps they were men, but I could not say for sure.
Could you tell the race?
¿Podría usted darse cuenta de la raza? Yes, black.
That's not what he said.
It is what he said. He translated from Spanish to English. You're not to get involved with the interpretation, okay?
When you spoke with me, you mentioned that you thought they were helping the guy out, correct?
Cuando usted habló, dijo que usted pensaba que usted hizo de que ellos estaban ayudándole a pagar sus impuestos, ¿correcto?
Sí,
Yes.
Do you help dead people up?
¿Se le ayuda para a las personas que están muertas?
yo no sé.
I don't know.
One moment. When you heard talking, how many different voices did you hear?
Yo escuché que hablaban, pero yo no escuché quién hablaba.
I heard that they were speaking, but I did not hear who was speaking.
Were they speaking calmly as if on a cellular telephone, or were they yelling or something different?
O algo diferente.
Despacio.
Slowly.
Did it appear to be a normal conversation or an argument?
¿Calmada o una discusión?
Se oían voces, pero yo no sé qué decían. Está retirado.
You could hear voices, but I could not hear what they were saying because they were far off.
Did you witness anything suspicious enough for you to call the police?
No.
No.
Thank you. Nothing further.
Any redirect?
Mr. Hyman, do you remember when the judge asked you a little while ago about whether someone was being carried or being picked up? Do you remember when the judge asked you that?
Sí. Cuando usted preguntó a ustedes que si alguien pues lo estaba agarrándose por ustedes. Sí. Yes, yes.
Do you remember you said that they were just really, really close together?
Yes.
Is that why you told defense counsel when you spoke to him previously that you thought they may have been helping him?
Yes.
Nothing further.
Thank you. Nothing.
Okay, jurors, questions for Mr. Hymas? Thank you. Counsel, if you join me, please. Be right back, Mr. Nance.
All right, y'all. So this was an old trial that we were just watching, but I actually just saw that there is the trial regarding the Orlando Magic player. All right, y'all. So this was an old trial that we were just watching, but I actually just saw that my bad, little feedback because I'm really watching from the TV. So the Orlando Magic trial, Orlando Magic. I think we're gonna switch over to that one. It's a really short one too, y'all. So we're gonna jump over to that trial and watch that one instead. So this is down in Florida as well. So Florida versus Lawrence Doherty.
Correct? All right. When we stopped yesterday, we had done the jury selection and I had given you the preliminary instructions. So we're now going to start with the opening statements of the attorneys and then start moving into the witnesses' testimony. So at this time, the attorneys for the parties will have the opportunity to make their opening statements in which they may explain to you the issues in the case and give you a summary of the facts that they expect that the evidence will show. State wish to give its opening statement at this time?
Yes, Your Honor.
You may do so.
Thank you, Your Honor. Court. On May 9th, 2022, this defendant shot and killed a Marine King. And you're going to hear the evidence in this case, and it's going to show that this defendant was not acting in self-defense. He was not standing his ground. He arrived back to his house at about 1:30 a.m. and he saw the victim's vehicle, which he recognized, parked a few houses down from his residence, parked on the street. He approached the vehicle. They had a brief word, and then the defendant goes back inside his house. The victim doesn't follow. He never leaves the area of his vehicle, which is parked on the street. But the defendant goes to his house. He locates his firearm. He arms himself with that firearm, and he comes back out. Now, mind you, you're going to hear from the evidence in this case that the victim was not armed. He did not have a firearm. He didn't have any weapons. You're going to see there was a photograph of a kitchen knife on the passenger floorboard, but there was nothing that he used to threaten in this circumstance. He was not armed. He was parked at least 10 yards away from the yard of the defendant. The defendant arms himself in his home, comes back outside his home, finds the victim still by his car. He takes that firearm out, he points it, he takes deadly aim, and he shoots and kills the victim in this case. That's the fact that you're going to hear in this case. So, you're going to hear through the witnesses and evidence in this case that the defendant was driven home that night
about 1:30 a.m. by his father. He had been in an argument with his girlfriend, Tatiana Mesa. They were at a family party at the defendant's father's house. You're going to hear that Tatiana Mesa, the defendant's girlfriend, called her best friend, Tara Walker, who is the victim's girlfriend, and asked if she could come over to the residence. Tara Walker speaks with her boyfriend, the victim in this case, and he decides to come to the residence or the area of the residence as well as backup. They all get there. Well, I guess the defendant arrives before Tara Walker, but she arrives shortly after, and the victim is already in his vehicle, parked on the street when he arrives. So the defendant had previously known the vehicle, as you're going to hear in the evidence, and he goes up and exchanges words. He's upset. You're going to hear from Tara Walker that the defendant appeared to be intoxicated at the time. Again, he didn't drive himself to his home. His father had driven him to his house that night. And, there's words exchanged, but that's not the point that the shooting happens. He takes the time, he goes inside, and he arms himself with the firearm. Now, you're going to hear from the medical examiner in this case, Dr. Marie Hansen, and she's going to tell you that the cause of death was the gunshot wound that went through the arm and the torso in this case, and that the manner of death was determined to be homicide. You're going to hear from several witnesses in the case, the primary one being Tara Walker, who was present and witnessed the shooting. And she's going to let you know, as I said, that the defendant appeared to be intoxicated, that he was upset, that he was belligerent. And I expect that you're also going to see some surveillance footage in this case. Now, the surveillance doesn't capture the incident itself, but there's a camera that's near a neighbor's camera that you can hear the shooting itself on the surveillance footage, and you can see the aftermath. And on that footage, you're going to be able to hear Tara Walker pleading with this defendant. Don't take your gun out. Don't take your gun out. We were called here. Don't take your gun out. You're going to see the defendant doesn't listen. He takes his gun out, he takes aim, and all in this moment, he shoots the victim and kills him. Now, after that, you're going to see Tara Walker run to the area where the surveillance camera is located, and you're going to see the defendant's son, Avian Doherty, is running with her, and then ultimately the defendant comes out and calls his son into the house. Now, you're going to hear from Tara Walker, and she's going to tell you the victim didn't have a weapon, that he didn't threaten a weapon. The evidence in this case will be clear. This is not a case of self-defense. This is not a case of someone standing their ground. As was discussed in jury selection, in a self-defense or stand your ground situation, the facts matter. And the facts in this case are not someone defending themselves. They're someone being the aggressor, taking aggressive action, arming themselves, and committing a murder. And once you've heard the evidence in this case, we'll ask that you convict. Thank you.
Mr. Thompson, does the defense wish to give an opening?
Yes, Your Honor. May it please the court?
You may.
Good morning again, ladies and gentlemen. How you doing today? Again, we just get right into this. This is not a complicated case. This is a very simple case. Okay? This is a case about self-defense. And not just self-defense of oneself, but we're talking about self-defense of one's family. Okay? Please pay close attention to the facts in this case. Every fact is very important. May 9th, 2022, Lawrence Doherty was celebrating Mother's Day with his family at his father's house, not very far from where this incident occurred. Okay? When he decided to leave, his father drives him home. Okay? Mr. Larry Doherty is the driver, Lawrence Doherty is a passenger, and his 10-year-old son is a passenger in the backseat compartment. Unknown to him, unexpected, as he arrives home, he observes a black Chevy, black tinted window, Chevy now, parked outside his car, lights, headlights on, car running. Okay? Out of concern, he starts to walk over to the car, and he starts to realize the car looks familiar to him. He believes it's the car of his long-term friend, lady friend, Sarah Walker. Evidence will show this is the car that she lived in during the month. It must be 6 months at a time. Mr. Doherty didn't know that was her car. He didn't know that was a boy in the car. He walks up, and then the tinted window rolls down. One can't see inside his car. It's 1:30 in the morning. It's dark out. Window rolls down. Mr. Doherty asks, why are you here? You want to know what happens next? Evidence will show that 6'8", at least 6'8", according to the medical examiner, is 8 inches tall. Just like 6'8", now she's tall. Steps out of the car, wingspan of 7 foot. With a threatening posture, steps out. I was smoking, what you want to do? What you want to do? Mr. Doherty immediately retreats to his home. Gets his firearm. Evidence will show that he's a concealed weapon permit holder. Evidence will show he didn't go and look for trouble. Trouble came with him. Right? His son is outside. He can't even make it into the house. He walks back out. But before that, he's still asking, why are you here? We need to leave. Guess what happened next, ladies and gentlemen? Mr. Doherty, after being threatened, walks into his home. He comes back out, and instead of Mr. Payne, the first one is Mr. Payne, his name is Adrian Payne. Mr. Doherty didn't know that. He only knew that somebody named Adrian. He didn't know him personally, he didn't know him at all. Right? As he comes back out, not only did Mr. Payne not leave, but he pulls the car up closer to this home. So he had the opportunity to leave. And the evidence will show that his girlfriend, Sarah Walker, actually told him to leave. She had arrived at the tail end of the verbal altercation. The evidence will show she wasn't even present when Mr. Doherty approached to ask him to see who he were. You heard testimony that she's going to say she's on the phone. She would admit to you that she told him not to come to the house. He did it anyway. The evidence will show he didn't even know where Mr. Doherty lived. He circled around the neighborhood to find, he found Mr. Doherty's car. He was familiar with the Mercedes-Benz or whatever it is. Right? Mr. Doherty comes back out, asks him to leave again. Not just that, why are you here? Simultaneously, as Mr. Payne reaches, Mr. Doherty fires one shot, not to kill, but to repel the threat. The evidence will show that bullet pierced through the bicep into his chest cavity. Only then he got back in the car. He was still standing outside the car. Okay? What did Mr. Doherty do next? He didn't flee. He immediately told his son to come get in the house, call law enforcement, reported to them what happened. Okay? He cooperated with the investigation. This is a case about self-defense. This is a case about defense of others. This case is very simple. The evidence would show that neither Mr. Lawrence Doherty or Mr. Doherty's fiance at the time invited Mr. Payne over. No one invited him over. The evidence would show that Mr. Payne's girlfriend advised him not to go, not to come. evidence would show that the crime scene wasn't really secure. It was contaminated before law enforcement arrived. The state is even being spoken in this administrative weapon call. Evidence would show that that weapon, that knife, was not tested to DNA. Fingerprints was not even taken in evidence. Evidence would show that Ms. Terry Walker had access to that vehicle before law enforcement arrived. You would hear evidence that no firearm was located. But there is a reasonable explanation for that. Okay? Evidence would show that. The evidence revealed the inconsistency in the state's evidence in this case. It's abundance of it. Evidence revealed lack of evidence in this case. This is a clear case of self-defense. After you've heard and seen all the evidence, we ask that you find Mr. Doherty not guilty. It's the right thing to do under these circumstances. This is not a case of a gunman on the loose, shooting bystanders and innocent people. This is a man who's on his way home, minding his business. Okay? This is not complicated. This is a case about a man who was forced to defend himself, his child, and his father against a much larger, aggressive man who showed up armed and threatening him at his home in the dead of the night, 1:30 in the morning. He didn't come singing a Christmas carol. He didn't come with any sense of kindness or respect. He came with intent to intimidate and threaten. And that's what he did. Evidence would show that Mr. Doherty did what any reasonable person would do in that situation. Ask, Mr. Payne, why are you here? Mr. Doherty asked Mr. Payne to leave. Did he leave? No. But more importantly, why was he there? How did you even know how to get to the house? Mr. Doherty was threatened by him. He immediately went in his home and protected himself and his family. Mr. Payne postured himself in a threatening manner while outside of Mr. Doherty's home at 1:30 in the morning. This is a case about self-defense. This is the case that the people of the state of Florida should recognize as self-defense. This is not acceptable. He's innocent. His actions are love. After you heard everything we prayed, humbly, and asked that you find out. That is the privilege to me.
Great, call your first witness.
Your Honor, at this time, we would move to offer into evidence what's been marked for identification as States E, the stipulation of the parties, and ask that be published.
Any objection from this defense?
No, Your Honor.
All right, what's been marked as States Exhibit E for identification will be received into evidence as States 1 without objection.
And Your Honor, if you could publish the...
All right, ladies and gentlemen, what is in evidence now as States Exhibit 1 is a stipulation of the victim's identification. It indicates that the Assistant State Attorney, Michael Joseph Smith, and the defendant, Lawrence Alexander Doherty, as well as his lawyer, Harold Dion Thompson, stipulate that the identity of the deceased in this case is Andrea D'Angelo Payne, and it is signed by all three parties. Okay? So that is a stipulated fact that you all can consider. All right, State.
Thank you, Your Honor. At this time, the State calls Garrett Morris.
solemnly swear or affirm testimony shall give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, go ahead and have a seat for me once you get situated. And state your full name for me and spell your first and last name for the court reporter.
Garrett Morris, Garrett Morris.
State your name, correct?
Thank you, Your Honor. Good morning.
Hi, good morning.
If you could just introduce yourself to the jury.
Yes, my name is Corporal Garrett Morris. I'm with Orange County Sheriff's Office.
And how long have you been with the Orange County Sheriff's Office?
For 5 years and total time in law enforcement, almost 13.
Where did you work in law enforcement before the Orange County Sheriff's Office?
Volusia County Sheriff's Office.
And what is your current job duty?
Currently, I'm a patrol supervisor in our Sector 3, west side of the county.
And what shift are you on?
Midnight shift.
Okay. Did you work last night?
I did.
Okay, so have you just come straight through from that?
Yes, I did.
I want to take you back to May 9th of 2022. Were you working at that time?
Yes, I was.
What was your position then?
At that time, I was a patrol deputy in Sector 2, which is the east side of the county. And I was
easel flip chart. Will that suffice? And we have markers and we have sticky notes. So those we're going to send back with you for your use. Table of contents of items. I'm not sure what you were requesting. Is it a listing of all the exhibits and evidence? Because if so, that was sent in with you. Okay. That should be in there. If you
It sounds like the jury was, they had a question. They were looking for some evidence and she basically just told them where to find it. So I won't spend too much time here. We'll go back over to the Orlando Magic trial. It sounds like the jury was, they had a question. They were looking for some evidence and she basically.
Yes, I did.
Where was he located?
So the victim, when I located him, he was in the driver's seat of I believe, a silver vehicle, and he was with his left foot outside of the vehicle and his right foot inside the vehicle.
Did he appear to be injured?
Yes, he had a gunshot wound to his chest, and he was unresponsive.
Was anyone else near the victim when you arrived?
Yes, the defendant's father was near the victim, and so was the victim's girlfriend.
And what happened from there once you arrived, located the victim, realized he had a gunshot wound? What did you do?
At that point, I put on my gloves and I got him out of the vehicle. The defendant's father assisted a little bit, and then I started CPR.
And you started CPR once he was out of the vehicle on the ground?
Yes, I pulled him out of the vehicle into a flat, hard surface, and that's when I began CPR.
Now, as part of, anytime you're going to perform CPR and walking into an unusual situation, is it part of your protocol to check for weapons?
Generally speaking, yes. Whenever, if I were to respond to a call where maybe there was somebody who was maybe just overdosed or something like a natural causes, I may not always check for weapons, but whenever in this case there's obvious that he had been shot, I check for weapons on whoever I'm in contact with, and in that case it was the victim.
And did you locate any weapons on or about the victim's person?
No, I did not.
Now, at some point, did fire rescue arrive and take over, I guess, the CPR and life-saving measures from law enforcement?
Yes.
And what happened from there as far as your involvement?
After that, I just assisted in maintaining the crime scene. I put up crime scene tape and held that area around the car until our homicide and forensics units can get there.
Now, during this encounter that you've just described, Were you equipped with body-worn camera?
Yes, I was.
And was that activated?
Yes, it was.
Have you had a chance to review that body-worn camera prior to today?
I have.
First, I want to show you what's been marked for identification as states composite D. It's 3 photos, or still photos from your body-worn camera. Let the record reflect I'm showing opposing counsel with the marked for identification as states D. Permission to approach?
You may.
Let the record reflect I'm showing the witness what's been marked for identification as states D. If you could just look through these and let me know if you recognize them.
Yes, I do recognize them.
Are these still images from your body-worn camera?
Yes, they are.
Are they a fair and accurate depiction of what was captured by your body-worn camera?
Yes, sir.
At this time, the state offers into evidence what's been previously marked for identification as states composite D.
Any objections?
No objection, Your Honor.
What's been marked as States Exhibit D for identification. Without objection, will proceed into evidence as States 2.
Commissioner Public wants marked.
You may.
States Exhibit 2. All right, what are we looking at here?
That's the victim on the ground with a gunshot wound to his chest. I don't know at which point that was during the CPR, but that was those gloves or me checking his fanny pack for any weapons.
I know you have a screen in front of you. Are you able to look sort of behind and see the screen behind you? Is that the gunshot wound that you observed?
Yes.
And then this here, is this a fanny pack that he's wearing?
Yes, it was.
And you went inside that fanny pack?
I did.
And did you locate any weapons or anything like that?
No, I did not.
And then, I know it's a little bit blurry, but what are we looking at here in this balloon?
That's the victim as I first found and observed him in his car.
Would this be like his leg here?
Yes.
This is inside the driver's compartment.
Yes, that's him sitting in the driver's seat, and I believe his left leg was out of the vehicle, and he was slumped backwards, unresponsive.
And finally, this still image, dark on the screen. It's in evidence. I don't know if you can actually see it here, but again, just to orient, this here area is that's the driver's seat.
Hmm. I can see the steering wheel and the victim's shirt.
And there's another individual, this picture here, you can see it, you're actually holding the photograph.
Mhm.
Is that the person that you understood to be the victim's girlfriend?
The female that was there was the victim's girlfriend.
We also had an opportunity to review a clip of your body-worn camera from responding to this incident. prior
Yes,
to that.
yes, I have.
Let the record reflect I'm showing opposing counsel has been marked for identification as states C. Permission to approach.
You may.
Let the record reflect I'm showing the witness has been marked for identification as states
Yes, I do.
Is that a disc of your body on camera that we reviewed together back in June?
Yes.
Is it fair and accurate?
Yes.
At this time, the state offers the evidence looking previously marked for identification as states.
Any objections?
No objection, Your Honor.
What's been marked as States Exhibit C for identification will be received into evidence as States 3 without objection.
Your Honor, permission to publish once marked?
You may.
Now publishing States Exhibit 3.
Have mercy. Oh, Jesus. Where's the ambulance
Alright, back up.
Yes, sir.
Back up.
Oh, Lord, have mercy.
County 125.
Oh, Lord, have mercy. Oh, Lord.
Black male, GSW to the chest, unresponsive, no pulse. I'm going to try to get him out of the car and start CPR.
Yes, ma'am.
Here, come on.
No, man.
Here, grab his legs. Let me get him out. You got him? Yep. Come on, pull him.
He's not breathing no more. He was on his chest.
Okay.
His head.
Alright, I got his head. Just pull him. Pull him away from the car. Alright, there we go. Give me light.
I got you. So we're inside you, member. Right now, I just need you to stand over on the side of the walk, alright?
Yeah, it's open. Wow. Got nothing.
There's no guns.
That's empty coming out.
And that concludes State's Exhibit 3. Corporal, did all the events we've just discussed, including your response, occur in Orange County, Florida?
Yes, it did.
I don't have any further questions.
Ross?
Good morning, sir. How are you doing today?
Good morning, sir. Good, thank you.
I'll just try to piggyback briefly off what you just testified to. Isn't it true you did not search the vehicle for weapons?
Yes, sir, it is. I did not search the vehicle.
And you just saw the video yourself, obviously. Isn't it true the right side passenger door was open?
I believe the girlfriend was standing at the right side passenger door, yes.
So it's fair to say, well, you didn't open the right side passenger door, right?
I didn't go to the right side passenger.
So it's, as far as you believe it was Mr. Payne's girlfriend who opened that door?
Objection calls for speculation.
Sustained.
You have no idea who opened that passenger side door and opened that door?
I do not know who opened that door.
All you know is by the time you arrived, that passenger side door was open, correct?
Correct.
And Mr. Payne was seated in the driver's side, correct?
Correct.
And there was no other person inside that vehicle at that time, correct?
Correct.
And you didn't search that vehicle, correct?
Correct.
You didn't search Tara Walker's, the victim's girlfriend's car either, did you?
No, sir, I did not.
I have no further questions.
You redirect?
No, Your Honor.
May the witness be excused?
Yes, Your Honor.
All right, thank you, sir. You can step down. Thank you, sir. All right, State, next witness.
Yes, Your Honor. At this time, the state calls Hannah Minor. Minor.
Swear, affirm testimony shall give, shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, go ahead and have a seat for me. And then state your full name and spell your first and last name for the court reporter, please.
Hannah Minor, Hannahminer.
All right, state your main inquiry.
Thank you, Your Honor. Good morning.
Good morning.
If you could just introduce yourself to the jury.
My name is Hannah Minor. I'm a crime scene investigator with the Orange County Sheriff's Office.
And how long have you been a crime scene investigator with the Orange County Sheriff's Office?
Since January of 2022.
And if you could just give the jury a little bit of your background as far as training experience that enables you to hold that position.
I have a bachelor's degree in forensic science from the University of Central Florida. I also have a master's in pharmacy with a concentration in forensic science from the University of Florida. And I'm currently working on a doctorate in forensic science from Oklahoma State University. In addition to that, I am a certified crime scene analyst with the International Association for Identification.
What is the role, if you could just explain to the jury, what is the role of a crime scene investigator?
We are notified to respond out to crime scenes. We document those crime scenes with photos, notes, sometimes measurements. We'll document evidence, collect evidence, process that evidence, package that evidence, forward the evidence to its final location, whether that's a laboratory or our evidence unit, and then we will write reports on our involvement for those cases.
And do you work in conjunction with law enforcement, like detectives and things like that?
Yes, we do.
So I want to take you back to May 9th of 2022. Were you working in your capacity as a crime scene investigator at that time?
I was the on-call crime scene investigator, yes.
So it might seem self-explanatory, but if you could just sort of describe, what does it mean to be the on-call crime scene investigator?
Our office is staffed until midnight, so any calls that come in after midnight, it goes to the on-call crime scene investigator, where they will take calls from home.
And were you directed as part of your job as the on-call CSI to respond to a location at 2529 Egret Shores Drive in Orlando?
Yes, I was.
And was part of your job to document that scene?
Yes, it was.
What time, if you recall, was it that you responded to that scene?
I arrived on scene at approximately 5 o'clock that morning.
Was it still dark outside, or had it begun to be light yet?
It was still dark outside.
Were you able to take some photos outside that scene before, I guess, the sun ultimately came up?
Yes.
And Your Honor, I've previously shown opposing counsel what's been marked for identification as states composite H. That's going to be photos. Permission to approach?
Yep.
Let the record reflect on showing the witness what's been marked for identification as states H composite of 6 photos. If you could just take a look at that. And are these photos that you yourself took as part of your duties on the unit?
Yes.
Are they clear and accurate?
Yes.
At this time, the state offers the evidence of the proof of identification as states H composite.
Any objections?
No objection, Your Honor.
It's been marked as States Exhibit H for identification. We've received the evidence as States 4 without objection.
And Your Honor, permission to publish once marked.
Okay.
Now publishing on the internet, States Exhibit 4. What are we looking at in this photo?
That's the front door of the residence.
When you say the residence, is that what you understood to be the defendant's residence?
That is correct.
And in this photo?
It's essentially the same photo, just zoomed out a little bit to show more of the surrounding area.
And are you documenting a white truck in this photo?
Yes.
Here's the stop sign. You see, I know you have the screen in front of you. Here's on circling with a laser pointer. This is documenting the location for the intersection of the area where this happened.
Yes.
And that white aisle is still visible here. Is that correct?
Yes.
And where is this in location to the defendant's residence? We just saw the photos of.
If you were standing facing the residence, this is to the left.
I know it's dark.
That is correct.
Dark in this photo, but what we're looking at here?
That is the victim's car.
In addition, another dark photo of the victim's car.
That is correct.
Now, after the sun did come up that morning, did you document the scene with some daylight photos, sort of capturing different items' location to each other?
Yes, I did.
Let the record reflect, I've previously shown opposing counsel what's been marked for identification as state's composite I-14 photographs. Permission to approach the witness?
You may.
Let the record reflect, I'm showing the witness what's been marked for identification as state's composite I-14 photographs. If you just flip through, you can let me have it. And these all photographs that you took during the daylight on May 9th of 2022?
Yes.
Are they fair and accurate?
Yes.
At this time, the state offers the evidence of the previously marked for identification of state's composite I.
Any objections?
No objection, Your Honor.
It's been marked as State's Exhibit I for identification will be received into evidence as State's 5 without objection.
Permission to publish once more?
You may.
So what are we looking at in this photo?
That is the white vehicle that was parked in front of the residence.
When you say the resident, you mean the resident you understood as the defendant?
That is correct.
And as we're looking forward in this photograph, what's depicted? Is this a stop sign that you've seen the earlier photo at night of?
Yes.
And then this vehicle, is that the victim's vehicle?
Yes.
So sort of it would be off screen in this photo, but like if we were to go over into this area, would that be essentially where the defendant's door would be located?
Yes.
So this would be sort of a perspective if you're standing in the defendant's car.
Objection as to leading.
Sustained.
What would this be a perspective of from where you're standing?
Could you clarify the question?
Right, so where were you standing when you took this photo?
On the right side or the driver's side of the vehicle.
And does this capture the distance between the defendant's residence?
Objection, Your Honor. Leading, best evidence rule. May we approach?
No, overruled.
Does this capture the distance between the defendant's residence and the victim's vehicle?
It documents it, yes.
What are we looking at here?
That's the passenger side of the victim's vehicle?
And obviously the door is open.
Correct.
Was the door open when you arrived, or did you open the door?
Can I refer to my report? The front passenger door was open.
And now we're looking at, is this the back passenger door?
The rear passenger, yes.
Now, did you open this door for this photograph?
Yes.
What are we looking at here?
The front quarter panel of the victim's vehicle.
And then is this just a different view of sort of directly into the driver's side of the vehicle?
Yes.
Now, this residence back here, this is not the residence that you wish to use.
That is correct.
And then is this just another photograph with both the front doors open?
That is correct.
What were you documenting with this photo?
That's the driver's seat. There are some red stains on the piece of paper that's on the floorboard.
When you say the red stains, is that due to the screen behind you? Is that what I'm circling with my laser pointer now?
That is correct.
And what are we looking depicted here?
That's the cup holder area of the victim's vehicle. There's additional red staining near the shifter.
This area here is on indicating the laser pointer.
That is correct.
Which is a closer view of that.
That is correct.
And what are we looking at here?
That's the passenger side of the victim's vehicle.
And what's depicted in this photo?
That was a knife that was on the floorboard, kind of near the end of the seat.
And what seat was that?
The passenger seat, the front passenger seat.
And what are we looking at here?
Another overall of the scene of the front of the residence and the two vehicles in the daylight.
So the front of the residence, you can look at this screen here. If you could just take the laser pointer, can you point out where you're understanding where the defendant's reference was? And then if you could point out with the laser pointer the location of the victim. Now, in this photograph, is this here on the bottom left of that victim's vehicle?
Yes, it is.
And so then if you could take a laser pointer and as best you can point out the location of the victim's truck.
This is the white car that was in front of the residence.
So the other, would it be the other side, the far side of the white car?
That is correct.
And then again, this shows the white car from the previous photo.
That is correct.
And then on the right side of the photo is that the door to the left.
Yes.
Did you actually actually enter the defendant's residence and document the interior of that location as well?
I did.
And let the record reflect, I previously shown opposing counsel what's been marked for identification. That states composite J. Permission to approach the witness?
You may.
Let the record reflect, I'm showing the witness what's been marked for identification. That states composite J. So you could just flip through those and let me know if you're done. Are these photographs that you took entering or inside of which defendant's residence?
Yes.
Are they very accurate?
Yes.
At this time, the state offers the evidence of the previously marked for identification as states composite J.
Any objections? No objection, Your Honor. It's been marked as State's Exhibit J for identification without objection will be received into evidence as State 6.
There's no public one more.
You may.
What are we looking at in this photo?
That's the entryway to the residence.
And then in this photo, have you stepped inside the residence?
Yes.
In this photo, or are you just a little bit, I guess, further inside the residence?
Yes.
What are we looking at here?
Another photo photographing the entryway, so the way I had just come through the residence from the sliding glass door from the previous photo.
So this would be you come in, and then you turn around, and I guess we'll put the photo looking back that way, is that correct?
That is correct.
What are we looking at here?
It's another overall photo just panning from that same location back toward where I just walked through the residence.
Now, in your documentation of the residence, was a firearm located?
Yes.
What are we looking at here?
It's a photo of the kitchen area where the firearm was located inside of that drawer that's open in the photo.
Okay, you could just take the laser pointer and point me through the drawer that you're referring to. And then is this photograph just looking at the drawer inside showing the firearm?
That is correct.
And then what is depicted here?
That is the firearm once I rendered it safe and placed it in a firearm box.
What does it mean to render a firearm safe?
In the original photo, the slide was forward, so there's no way for me to know if the firearm was loaded or not. So in order to render it safe, I take the magazine out, which is the item on the right, and then lock the slide back to make sure that the chamber is empty so that it's safe to handle.
Fair to say, previous to this photo, the magazine was inside the firearm?
That is correct.
Now, that firearm that we just saw the photographs of, was it ultimately collected and placed into evidence?
Yes, it was.
Let the record reflect, I'm showing opposing counsel what's been marked for identification as State B. permission to approach the witnesses?
Go ahead.
Let the record reflect, I'm showing the witness what the mark for identification is. State B, if you could just take a look at this and let me know if you recognize that as a firearm that you collected from it.
Yes, it is.
And that was placed in evidence by you.
Yes, it was.
At this time, the state offers in evidence what appears to be marked for identification as state B.
Any objections? No objection, Your Honor. It's been marked as states for identification without objection. Be received into evidence as state 7.
Your Honor, permission to have the witness get off the stand and publish to the jury.
You may.
Then I can step off the stand and actually, later in the course of your duties as a CSI in this case, were you tasked with collecting from the medical examiner a projectile or bullet recovered from the victim in this case?
Yes.
Let the record reflect I'm showing opposing counsel what's been marked for identification as states A. Permission to approach.
You may.
Let me know if you can tell from markings or if you can but I'm showing the witness what's been marked for identification as state A. Do you recognize this?
Yes.
And how do you recognize it?
The label has the case number, the location collected, a description that says sealed container labeled bullet from right abdomen. It has my name and EID on it and my initials and date that I sealed the item on the tape.
And is that the bullet or projectile that was recovered from the autopsy?
Yes.
And at this time, the state offers into evidence what's been previously marked for identification as states A.
Any objections?
No objection, Your Honor.
What's been previously marked as States Exhibit A for identification without objection will be received into evidence as States 8.
Beyond what we've discussed, did you document any further scenes in this case?
No.
Did you have any further involvement?
Just my response to the medical examiner's office.
And did all the events, all your investigation occur at the residence located in Orange County?
The initial call out response, yes, was only at the residence.
I don't have any further questions. Thank you.
All right, Cross.
Yes, Your Honor. Good morning. How you doing, Investigator Minor? How you doing today? Just briefly, I want to ask you some follow-up questions. How long you said you've been a crime scene investigator?
Since January of 2022?
January of 2022.
Correct.
And this incident occurred in May 2022, correct?
Correct.
So about 4 months. At the time of this incident, you had been a crime scene investigator for 4 months, correct?
Correct.
Okay. Is it fair to say this was your, close to like your first actual one in the field solo?
No, it was not.
Okay. Were you supervised by anyone?
Yes, I was.
Okay. When you, obviously, crime scene investigate, do you guys wear body camera footage? You don't do stuff like that, do you?
We do not.
And you arrived at this scene about 4 hours after the incident actually happened, correct?
I don't know what time the initial incident was reported.
Is that not something you would put in your report or something you think relevant for crime scene documentation?
I document the time I was notified that my response was required, the time that I arrived on scene, and the time that I cleared the scene.
Okay, what time were you notified?
Approximately 4 o'clock in the morning.
4 in the morning. And what time did you arrive? 5 in the morning?
Correct.
And as a part of your documentation, can you tell me again what your functions are? You say you document, but just walk me back through it briefly.
We respond to the scenes. We document them with notes, photography, any other processing methods that are deemed necessary for this specific case. We collect the evidence once it's been documented. We'll process that evidence. We will send the evidence to their final destinations, whether that's a lab or our evidence unit, and then we will write reports on essentially what is our involvement with each case.
Perfect, perfect. So I noticed you said you collect evidence, correct?
That is correct.
Isn't it true it was also a knife in the car that was not taken into evidence by you?
Yes.
When you arrive on the scene, is that a part of your duties to dust for prints or try to obtain DNA? Is that part of your job?
It can be.
When you say it can be, I mean that's something that you usually would do?
It's a case-by-case circumstance.
So in a case where someone is alleged to have been murdered or shot, you notice this blood spatter in the car. Is that not a case where you would dust for prints or dust for DNA if a weapon is located in the car?
It depends on the case circumstances.
Would you consider a knife a weapon?
It can be.
So I noticed you took a lot of pictures of Mr. Payne's vehicle. Let me go back a little bit. Are you aware of the vehicle, the owners or the persons that are said to be the owners or operators of the vehicles that you took picture of?
No.
So the black vehicle, the Chevy Malibu, you don't know who owned that car or drove that car?
It was my understanding that it was being operated by Mr. Payne.
Okay. Were you aware that Mr. Payne's girlfriend had a vehicle that was on the scene as well?
No.
Isn't it true you didn't take a picture of that vehicle?
I don't know what vehicle it is, so I don't know if it's in my photos.
Not even aware of it at all, correct?
Correct.
So it's fair to say you didn't take a photo of it?
I don't know what the car is. It could be in the background of one of my photos, so I don't know.
Okay. Did you take a photo of a white Audi truck SUV?
Not to my recollection.
You took a photo of a white truck, correct?
Yes.
You took a photo of a white Mercedes Benz, correct?
Yes.
You took photos of a black Chevy Malibu, correct?
Yes.
So if you were to learn that Tara Walker, Mr. Payne's girlfriend, drove a white Audi vehicle and it was on the scene of this incident, you would agree that you did not document that vehicle?
Not to the same extent that I did the others.
Did you document a white Audi in your report at all?
In my report, no.
Had you knew of a white Audi vehicle being on the scene, would you have done that?
Depends on the case circumstances.
Okay, I want to make sure I ask you this clear because I'm not trying to trip you up. As far as your records and your reports, did you document a white Audi vehicle on the scene?
In my report, no.
Okay, thank you. So it's fair to say you don't know what was inside of that vehicle.
If I did not document it, I would not know what is inside of it.
Thank you. just to be clear, part of your duties are to collect evidence, correct?
That is correct.
No further questions, Your Honor. Thank you.
Any redirect?
No, Your Honor.
May the witness be excused?
Yes, Your Honor.
All right, ma'am, you can step down. All right, let's take about a 5 or 10-minute recess, and then we'll pick up with the remainder of the witnesses for the morning, okay? All right, so, ladies and gentlemen, if you can step back in the jury room, if you need to use your restrooms or whatnot, we'll give court staff a break, and then we'll come back in about 5 or 10 minutes and resume, okay? All right. Thanks, sir. All right, have a seat for me. And then, sir, go ahead and state your full name and spell your first and your last name for me.
Marco Antonio Quintanar Gonzalez. Quintanar is Quintanar. Marco, Marco.
State your name, Inquiry.
Thank you, Your Honor. Good morning.
Good morning.
If you could just introduce yourself to the jury.
I'm Marco. I live in the corner of where the incident happened. I'm just a neighbor.
And you live in the city of Orlando?
Correct.
Okay. Now I want to take you back to May 9th of 2022. Did you have surveillance cameras at your home?
Correct. I had one at the garage.
Okay, what type of surveillance system did you use?
It's a Nest camera by Ksoo.
Nest by Google?
Yeah.
And if you could just give the jurors a sort of specific location of where that camera is located.
So basically in the entrance of the garage, just in the middle of the garage, it's pointing to the driveway towards the street.
Now, does that camera have both video and audio capacity?
Correct.
And did it capture the audio of an incident that occurred in the early morning hours of May 9th of 2022?
Yeah, that's correct.
And were you able to provide that footage to law enforcement?
Yes, I did.
How is it that you were able to access that footage?
So basically through my phone in an app, I just selected the time and hit download and provided that to the law enforcement.
Now, for that app, do you have like a secure login that you're able to go in and locate footage from your camera?
Yeah, I mean, you have to log in with your email and password to do that.
And you were able to access the footage and then provide that footage to law enforcement?
Yeah, that's correct.
Before you provided the footage to law enforcement, did you, other than selecting specific time frame, did you edit the footage or change it in any way?
No, not at all. I just selected it and downloaded it.
Who all has access to that footage? Does anybody else have that app?
My wife.
And again, you or your wife didn't tamper with or edit the footage you provided to law enforcement in any way?
No, not at all.
Let the record reflect I've previously shown opposing counsel what's been marked for identification as states F. Permission to approach the witness?
You may.
Let the record show that I've shown the witness what's been marked for identification as states F. Do you recognize it?
Yeah, it's the video footage recorded in CD.
And we reviewed this footage together back in June?
Correct.
Fair and accurate?
Yes.
At this time, the state offers any evidence of the previously marked for identification as states F.
Any objections?
No objection, Your Honor.
What's been marked as previously as States Exhibit F for identification were received into evidence without objection as States 9.
Table reserved publication. Now, you yourself weren't a witness to any incident, right? You just located the footage?
Yeah, no. At that time, we were up because I have a son that at that time was 4 months old. He wake up to be fed. So basically, we were about to get back to sleep, and we hear the gunshots. And I wasn't really sure, so I have to open the app and hear that. So yeah, and then the next morning, an officer knocked at my door. He asked if the camera captured the moment, so I said yes, and he requested that video.
So hearing the shot is what caused you to go and look at your camera to see if it captured anything. Is that fair to say?
Yeah, correct.
All right. I don't have any further questions. Thank you.
Ross?
Yes, briefly, Your Honor. Good morning, sir. How are you doing today? You stated, so isn't it true you didn't actually see the verbal altercation that transpired outside?
Yeah, that's correct.
Could you hear the altercation?
No, I mean, I just hear the gunshots, and then when I opened the app, I could hear the altercation through the video.
So you were able to hear the altercation when you looked at your video, correct?
Correct.
So you agree it was an actual verbal altercation prior to a shooting, correct?
Correct.
All right. And the videos that you provided to law enforcement, how many videos were there?
Just one.
Just one. Was it one long video, or was it, like, do you recall?
No, probably it was about a minute long.
10 minutes long?
1 minute.
1 minute long?
Yeah.
And isn't it true the video that you provided to law enforcement doesn't actually capture Mr. Lawrence Doherty and Mr. Payne in any frame of the video?
No, it doesn't. It doesn't show that.
So essentially, it just shows a headlight illuminating in the area, an argument occurring, and then a gunshot, correct?
Yeah, but it's basically the audio what the police was interested in.
Thank you. No further questions.
You redirect?
No, Your Honor.
The witness step down?
Yes, Your Honor.
All right, thank you, sir. All right, next witness.
Yes, Your Honor. At this time, the state calls Tara Walker.
You solemnly swear affirm testimony you shall give shall be the truth, the whole truth, nothing but the truth, so help you God.
Have a seat for me. You can state your full name for me and spell your first and last name for the full report.
Tara Helena Walker, T-A-R-A, last name is Walker, W-A-L-K-E-R.
I just need you to speak up a little bit.
Okay.
Thanks. You may inquire.
Thank you, Judge. If you could just introduce yourself to the jury.
Hi, I'm Tara Walker. I'm Adrian's girlfriend.
And what city do you currently live?
Orlando.
Now, are you currently employed?
Yes. I work at Baptiste Dentistry.
Now, I want to take you back. Do you know a person named Lawrence Doherty?
Yes.
How do you know that person?
He was my best friend's boyfriend.
And who is your best friend, or who was your best friend that you're referring to?
Tatiana Mesa.
Now, over the years, first of all, how long have you known Lawrence Doherty?
At that time, 15 years. About.
At that time, I assume, are you talking about the time of the incident back in?
Correct, yes.
2022?
Yeah, because now it would probably be around like 18 years.
So going back to 2022, how long had you known Lawrence Doherty?
15 years.
And over the years, would you say that you maybe encountered Mr. Doherty 100 times more?
Yes, more.
Would you recognize him if you were to see him today?
Yes.
Is he in the courtroom?
Yes.
Can you point him out and describe something he's wearing for the record?
He's right there and he's wearing gray.
Let the record reflect the witnesses identified the defendant.
So noted.
Now, going back to May of 2022, did you know a person named Adrian Payne?
Yes,
How did you know Mr. Payne?
I was in a relationship with him.
How long had you been in a relationship with him?
5 years.
And did you have any children in common?
Yes,
How many?
1.
So I want to take you back to the early morning hours, sort of after midnight on May 9th of 2022. Did you ever go to the defendant's neighborhood in the early morning hours of May 9th, 2022?
Yes,
When you arrived in that area, where did you go specifically?
in the middle of the street.
What vehicle were you in?
My car, I was in an Audi Q5.
And was the area you went to, was that Egret Shores Drive area?
Yes,
And is that in Orange County?
yes.
Now, why is it that you decided to go to that area?
Tatiana had texted me and asked me to meet her at her house in 15 minutes.
Okay. And so did you agree to do that?
Yes,
And was your understanding that she had been in an argument?
Objection as to leading.
Your Honor, can we approach? So you said you had received a call from your friend Tatiana Mesa,
a text message, yes.
and your understanding was that she had had some sort of argument with the defendant?
Correct.
And so you agreed to meet her at the residence?
Correct.
So at some point after speaking with Tatiana, did you have any kind of contact with Adrian Payne?
I did, yes.
Can you describe that contact?
He was on his way back to my house. It's Mother's Day night. He had left and he was coming back. And I told him that I was going to go to Tatiana's house to see what was going on, that she had asked me to come to her house and that she had called the police.
Objection, Your Honor. Under hearsay, we approach.
Oh, no.
So what happens when you first arrive at the area of the defendant's residence?
Larry, his father, is parked in the middle of the street near the stop sign, and Adrian's car is about 7 houses down, and Lawrence and him are outside of the car having a conversation.
Okay. And so you witnessed them having a conversation. What did you do from there?
I stopped in the middle of the street. Larry was standing outside of his vehicle. I rolled down my window. I lowered my phone down because I was on the phone with Adrian. And he told me to get back, that he was going to get his gun. And I was like, you know, what?
So let me stop you. Who told you to get back he was going to get his gun?
Larry.
Larry said he was going to get
Larry did, yes, correct.
Okay.
And I was like, what are you talking about, Larry? That's Adrian. That's Harmoni's dad. That's my boyfriend. And then he said, oh, that's a big fella. I'd never seen him before. And I was like, yeah.
And this is Larry, again, this is your understanding of Lawrence, the defendant's dad?
Correct.
So then what happened from there?
So I put the phone back to my ear. I was looking straight. I see that Adrian has his arm on top of the car. And he has one arm over the door. He's in between the crease of the door. Lawrence is standing on the side of here, the side of him. And I heard him say something like, get on, Lawrence, I'm not worried about you. Lawrence backed up. Adrian closed the door. Lawrence walked to the house, and Adrian walked over to me.
Okay. So at this point, the defendant has gone back inside the house?
Yeah, so we were about 7 houses down from his house, so he walked through the back, like on the grass, maybe around his backyard.
Okay. And then you have a conversation with Adrian?
Correct. He walks over to me. He walks in the middle. Larry is still there. He's getting into his car. They kind of just like nod heads. He gets in his car. He reverses and he pulls to the front of the driveway. Adrian's talking to me. I asked him, are you okay, babe? He said, yeah. Are you okay? And I said, yeah. Go back to your car and just pull up, and I'm going to park right here, which was like guest parking on the side of the house.
And did he go back to his car?
He did, yes.
Now, in that interaction that you had with him, did you observe him to be armed with any firearm?
No.
Did you observe him to be armed with any other weapons, like a knife or anything like
No.
that? And so, does Adrian actually go back to his vehicle?
Correct. He walks back to his car. I park my car where I say I'm going to park it. He pulls up to the spot where we were originally at, where Larry and myself was located.
So he pulled the car up to that spot?
Correct.
Now, that spot, where was that in location to the defendant's residence?
So we were in front of someone's house and across the street, and then the street, and then it's a townhome. So there's one house and then their house.
Okay.
So stop sign, their house, and then his house. I don't.
And so at some point, did the defendant come back outside of his residence?
Correct.
Are you able to estimate about how long that was? Obviously, I know you didn't have a stopwatch on you.
I know it wasn't less than 30 seconds. I mean, it had to have been like a minute and a half, maybe. It was somewhere.
At some point, did the defendant come back outside of his house?
He did.
When did you first notice that he had come back outside of his house?
So I parked my car. I walked over to Adrian. He opened his car door. He stuck his left leg out. I thought he was getting out the car. He had his hand on the steering wheel. And I said, babe, don't get out the car. I'm going to go see what's going on with Tatiana. And I turned around. I probably took about 5 steps. And then I seen Lawrence coming from in between the cars. Like there was another car and then a Mercedes, which is his car. And he had his arm under his shirt. And he came to the edge of it. I stopped. I asked him not to draw his weapon. What was he doing? His dad was asking, what was he doing, son?
Hearsay. Sustained.
Without getting into what anybody else was saying, what did you observe?
He came down to the end with a gun under his shirt. He took the gun out of his shirt. I asked him not to raise his weapon. I started to yell his name, Lawrence. And then from there, he asked us he asked, why are you here? He asked a couple times, maybe like 2 to 3 times. And I tried to explain to him, Tatiana asked me to be here.
Okay. And so at some point after he's walked out, he's now taken his firearm out.
Yeah.
And where was he when he had the firearm out? How far was he from Adrian's vehicle?
Not far. He was at the end of their street. I mean, at the end of the grass, the neighbors. So I don't know how to explain it unless I show you.
Walked down. Let me. Your Honor, this is in evidence of state exhibit 5. Are you able to see my laser pointer on the screen? Yeah. Okay. So I'm going to have you take the laser pointer if you could.
Okay.
And you hit this button here.
Okay.
And then just point at the screen where Adrian's vehicle is located.
Right here.
Okay. Now, with the laser pointer, if you could just sort of circle an area where the defendant was when he fired the shot. So he had walked a few places down from his residence, is that fair to say?
Objection as to leading, Your Honor.
Sustained.
Move to strike.
Well, no answer has been given. You can rephrase.
So if you could just, with that laser pointer, can you circle where the defendant's residence was? Okay. And then if you could just sort of walk down with a laser pointer showing the jury where the defendant had walked to at the time he fired the shot. And is he on the grass area?
Correct. Yes.
Okay. Now, you had some interaction, you said, with the defendant as he came back out?
Correct.
And were you able to observe his demeanor?
Yes.
What was his demeanor like? Was he even keeled? Was he upset?
It seemed like he was intoxicated.
Overruled.
He appeared to be intoxicated to you?
Correct. Yes.
Now, after the defendant shot Mr. Payne, what happened from there?
I turned around to run towards Adrian or, get to him. His dad grabbed me, and spun me around, and told me that I needed to run.
Or it's not offered for the truth of the matter asserted, it's direct.
We're not going to have the arguments in front of the jury either, so let's come on up.
Okay, so after the shooting, you were saying what happened next? You can continue.
I spun around, turned around to get to Adrian. Lawrence's father grabbed me, spun me around, and told me I needed to run, to grab Havian and run.
Did you do that?
I did. I ran over I walked over, I tried to run, my legs felt like bricks. I went to him, I opened the car door, he jumped into my arms. He was already crying. I put him down because I couldn't carry him, and I told him to run. So we started to run. Larry ran over to Adrian.
Okay, now let me stop you there. So you run after this, and you run a few houses down, is that fair?
Yes.
Have you had an opportunity to see some surveillance footage that shows you after sort of running down, also that captures the audio of the shooting?
Yes.
Let the record reflect I'm showing opposing counsel with the mark for identification as state G. Permission to approach? Let the record reflect that I'm showing counsel with the mark for identification as state G. Do you recognize this?
Yes.
And how do you recognize it?
My initials.
Is it a fair depiction of what was captured?
Yes.
At this time, the state offers an evidence of the previously marked for identification as state G.
Any objection?
No objection, Your Honor.
All right, what's been marked as State's Exhibit G for identification without objection will be received into evidence as State's 10.
And Your Honor, if I could just have a moment to set up the player. Now publishing States 10. All right, so I want to go back through that and ask you a few questions about some of the voices and things that we're hearing on the video.
Okay.
That voice that we hear there, is that your voice?
Correct, yes.
And what are you saying there?
Do not pull your gun out.
Now, I want to stop there. You said something after "do not pull your gun out." What was it that you said?
Lawrence? I didn't. Me?
We hear some yelling there. Who is yelling?
Larry,
Larry would be
his father.
So, are these two individuals, and I'll take a look at the screen behind. Who is this? And then who is this person? You hear a person saying, "Get in the house." Whose voice is that?
Lawrence.
The defendant?
Correct.
I'm going to pause here. If you could look at the screen behind you. You see my laser pointer? Who is this person? That's the defendant.
Correct.
That is State 10. State was now published. It's already been entered into evidence as State 9. So the voice that we hear sort of at the beginning of that, I'm going to turn it back up, but as much as I can. Is that your voice again?
Correct, yes.
And is that sort of a different camera that caught sort of the same audio or similar audio to the other surveillance that we just reviewed?
Yes.
briefly on the video. Let me- On the video that we just watched, we saw you sort of run by to that neighbor's residence.
Yes.
After that video ends, what do you do?
I run down a little further and I'm banging on doors.
At any point, did you go back to, how long after that would you estimate that law enforcement arrived?
Oh, I don't know. It felt like forever.
At any point, did you go back to the area where Adrian was located, where his vehicle was located?
Yes, I heard Larry.
I don't want you to get into anything that anybody else said. I just want you to tell me what you did.
I ran back.
Okay, so you went back to that vehicle?
I did.
And then what did you do when you got back to the vehicle?
I went to the driver's side. I put my keys on top of the car and I looked to see if he was alive.
Okay. Did he appear to you to be alive?
No. So
What did you do from there?
I ran around to the passenger side. I tried to readjust his head because he was leaning over into the middle with his head up, and I needed to fix him so I could try to do compressions because I couldn't get him out the car.
Okay, and then so you go around the passenger, you open the passenger side door.
I do.
And then what happens from there after you try to reposition his head?
I start the compressions. I'm telling Larry
Trying to do, sorry to stop you. You're trying to do the compressions in the vehicle?
in the vehicle. We can't get him out.
Then what happens?
I tell Larry, you have to help me. He's not breathing no more. And he starts screaming. He leans down and he starts doing them with me. So we're both pushing on his chest.
And then, so you're there with Larry. Are y'all there with the vehicle and with Adrian trying to render aid to him?
Yes.
Until law enforcement arrive?
Yes.
At any point, did you observe a firearm in the vehicle?
No.
Overruled. Calls for yes or no answer.
No.
Now, let me show you this is again in evidence and it's deposit 5. You recognize that?
Yes.
What is this a photo of?
My kitchen knife.
And is this from Adrian's vehicle, the passenger side?
Yes.
Why, if you know, was this knife there?
Objection is speculation, Your Honor, and lack of foundation.
Overruled. The question was why, if you know.
You can answer.
I put it there.
And I'm sorry, what was the answer?
I put it there.
And why was the knife there?
We had went to dinner before he'd left overseas.
Okay, so you had put the knife there previously?
Correct, yes.
And you, from dinner?
Yes, correct.
Had you left the knife in the vehicle?
Objection is for leading, Your Honor.
Overruled.
Had you left the knife in the vehicle?
Yes, I did.
About how long before this incident was the knife?
Maybe 4 months. He went overseas. I was driving his car. He was only home for, okay.
So about 4 months?
Yes.
And then he had been obviously not around his vehicle.
Objection is counsel testifying, Your Honor.
Sustained.
You had stated that shortly after this, he was away, is that right?
Correct.
And then how long before this incident had he been back?
19 days.
All right. So that knife that we just saw the picture of, at any point during this incident, did you see Adrian with that knife on his person?
No.
Did you ever see him threaten anybody with that knife?
No.
Now, you previously said that you didn't observe a firearm on Adrian or in the vehicle, is that right?
Correct.
Did you, and I know this is going to seem like I'm not trying to, embarrass you or anything, but did you take a firearm and hide it at some point during this incident?
Overruled. It's a yes or no answer.
No.
And you remained, did you remain in the area of the vehicle until law enforcement arrived on scene?
Yes.
And at some point in the early morning of May 9th, did you ultimately speak with law enforcement?
Yes.
And did you remain on scene to do that?
Yes.
All right, I don't have any further questions at this time.
Ross?
Yes, Your Honor, briefly, if I may.
Go ahead.
Good morning. How you doing, Ms. Walker?
Good morning.
Today? I'm just try to follow up with some things that you're just saying on direct. I'm not trying to trip you up. I know this is a very sensitive situation for you. Isn't it true that when the initial verbal altercation occurred between Mr. Doherty and your boyfriend, Adrian Payne, you were not present at the scene physically?
I pulled up. I was driving up.
Isn't it true Mr. Payne was on the scene before you were, correct?
Correct.
Right. And by the time you were pulling up, you had began to hear communication that you believe was the voice of Mr. Doherty, correct?
Correct. I believe him
Okay.
and Adrian had a conversation.
Isn't it true you had actually told Adrian Payne not to come to that house, correct?
Correct.
And the type of vehicle you were driving was an Audi Q5, right?
Correct.
After you told Adrian not to come, he told you, no, I'm on my way. I'm already there. I'm on the I-4, getting off the I-4. I'm on my way. I'm almost there, right?
He said he was coming off of the 408
408, I'm sorry.
and that he would meet me there.
Okay. But he didn't, in fact, meet you there. He was already there when you arrived, correct?
Correct.
At some point, when you pulled up, you previously testified that you saw Mr. Doherty's father present at the scene as well, right?
Correct.
And when you saw Larry Doherty, he told you, watch out, Terry, I'm about to get my gun, correct?
Correct.
This is Mr. Doherty's father telling you he's about to get his gun, correct?
Correct.
Not Lawrence, right? And that was based off what he had observed prior to you arriving, correct?
Correct.
You've known Larry Doherty for a while, right?
Yes.
Lawrence's dad, right?
Yes.
You're aware he's former military, right?
Yes.
So at some point during this verbal altercation, Mr. Doherty walks away into his home, right?
Yes.
But before he did that, he actually asked Adrian Payne, why are you here? Right?
I can't recall, but I've said it.
You were on the scene, right?
Correct.
Are you saying you didn't hear it or you just don't remember?
He's asked him that he asked that question when he was sitting in the car behind me.
You said we were sitting in
When he was sitting in the car behind me, he asked that question.
Who was sitting in the car behind you?
Adrian.
Behind your car?
No, I was standing in front of his doorway when he got shot. I didn't know if he was talking to me or Adrian.
Isn't it true that instead of Mr. Payne leaving, when Mr. Doherty went in the house, Lawrence Doherty, he moved his car up closer to the home, correct?
I asked him to.
You asked him to do that.
Yes,
But it's correct. He did, in fact, move his car closer to the home, correct?
correct,
This is 1:30 in the morning, at least, correct?
correct.
How tall was Mr. Payne? About five? No, he was 6'10", right? 247 pounds, correct?
I can't say 240.
Big guy. Is it fair to say he's a big guy? Okay. You're aware of how tall Mr. Doherty is? Lawrence, he's about 5'8", right? Right. But you also told Mr. Payne to get back in the car, right? You actually verbalized to him to get back in the car.
I asked him to go to his car and pull his car up.
So after Mr. Doherty, Lawrence Doherty, fired one shot in the direction of Mr. Payne, it's your testimony that Larry Doherty, Lawrence's father, told you to run, right?
Yes, sir.
We previously saw that video that was just showed. It wasn't just you running, right? It was a little 10-year-old boy running as well, right?
Correct.
So it's fair to say it was Mr. Doherty's, Lawrence's son was outside during this incident, right?
He was inside of the vehicle.
He was outside the house, correct?
Correct.
Okay. And let's get this straight. Did Mr. Adrian Payne live there?
Where?
At the location he was supposed to meet you at?
No.
Did he live there? Okay. Did Tatiana Mesa, Mr. Doherty's girlfriend, did she invite him over there?
She invited me.
Did she invite Adrian Payne there?
No, she invited me.
Thank you. You stated that it took some time for law enforcement to arrive at the scene, right? It felt like forever?
Correct.
At some point, you walked over to the passenger side of this Chevy Malibu and entered the vehicle, right?
Correct.
And it's your testimony that you entered it to straighten up Mr. Payne's head?
Correct.
You said you started compressions as well?
With Larry, yes.
At some point, isn't it true that you left the scene at some point, but your brother picked you up, right?
I left around 7 a.m. after they told me I could leave.
Before 7 a.m., you had left the scene too, correct?
No,
You never went to Mr. Larry Doherty's house?
I was after 7 a.m.
It was after 7 a.m.?
Yes.
Your car was still at the scene?
Correct.
Your brother came to pick you up, right?
At 7 a.m.?
That's how you left the scene. Your brother came to pick you up?
Yeah, he came at 2 o'clock in the morning.
He came at what time?
2 a.m.?
He came at 2 o'clock in the morning?
Mm-hmm.
And you didn't leave till 7?
Correct.
So your brother was on the scene for 5 hours with you?
Correct.
What kind of car did your brother drive?
At that time,
Yes, ma'am.
BMW?
Wasn't it true someone else came to the scene as well? Was it your father?
Correct.
Around what time did he arrive?
3, maybe?
Okay. This was after you had entered the vehicle to straighten Mr. Payne's head, correct?
Correct.
And although you had a vehicle, an Audi, right? You left with your brother, right?
Correct.
And this kitchen knife that was in the car, it was in that vehicle for 4 months, you said?
Yes, roughly.
Because you used to drive that vehicle, right?
Correct.
So that would explain how Mr. Doherty may have been somewhat familiar with the vehicle at some point.
Correct.
No, this sounds like a very ignorant question, and pardon my ignorance, but it was fair to say you love Mr. Payne, right?
Correct.
You wouldn't want him to have a bad name, would you?
No.
It's true, you would do anything to protect his name, right?
What do you mean by anything?
Is that fair? Would you?
No, not necessarily.
No further questions, John.
You redirect?
Yes,
So at any point from when you first arrived on scene and you saw Adrian's vehicle up until the moment he was shot, did you ever observe Adrian set foot on the defendant's property?
No.
Now, by the time the defendant came back out with the firearm in this case, was Adrian already back in his car?
Correct.
And at the time, in the moments before Adrian was shot, did he have a weapon?
No.
And did you witness him make any threats
Mm.
to the defendant at that time?
No.
And were you in a position that if he would have made such threats, you would have heard them?
Yes.
I don't have any other questions.
All right, step down.
Yes, Your Honor.
All right, thank you, ma'am. All right, ladies and gentlemen, we're just a little bit past noon, so we're going to take our break for lunch. You're free to go about your business for lunch. Just the same rules apply. Please don't do any research, looking up of any names, maps, any investigation on your own. Also, if you happen to see myself or any of the parties or anybody else involved in the case and we don't pay attention to you, that's because they've been instructed not to have any contact with you since you are the members of the jury. And we want to make sure that there's no appearance of any impropriety, okay? I'm going to have you all come back at 1:30. That'll give you a little time to get out of the building, try and find some place to eat, and then get back in to the building. We'll be ready to go sharply at 1:30. So once you all are assembled in the jury room, we'll bring you back in and get started, okay? Enjoy your lunch.
All right.
All right, seat. Before we adjourn for lunch, anything from the state?
Nothing from the state.
Defense? Just for planning purposes, roughly how many more witnesses this afternoon?
I plan on calling 2 witnesses this afternoon, the medical examiner and a firearms expert. And then from there, I plan to rest.
Okay. Spell your first and last name for the court reporter, please.
Dr. Marie H. Hansen, Mariehansen.
State your inquiry.
Thank you, Your Honor. Good afternoon.
Good afternoon.
If you could just introduce yourself to the jurors.
I'm Dr. Hansen. I'm an associate medical examiner at the District 9 and 25 Medical Examiner's Office. And I'm a forensic pathologist, which means I'm a medical doctor. I'm a pathologist. I did 4 years of anatomic and clinical pathology residency. And then I did a forensic subspecialty residency and have passed the national board exams and thus am board certified in anatomic, clinical, and forensic pathology.
Thank you, Doctor. And if you could just give the jurors a little bit of your educational background to hold your current position.
I have a BS in chemistry from the University of Wisconsin-La Crosse. I have a medical degree from the University of Minnesota. I have an anatomic and clinical pathology residency in St. Paul, Ramsey, and I have a forensic pathology residency in Miami, and I've been a practicing medical examiner since 1990.
Now, your current position in Orange County, how long have you had that position?
Since November of 2002.
And in that position, do you have to undergo periodic continuing education?
Yes.
And are you up to date with all the required continuing education?
Yes.
Now, as part of your work as associate medical examiner, is part of your job to perform autopsies?
Yes.
Can you describe to the jury what an autopsy is?
An autopsy is a gathering of history and then looking at a person, documenting the external surfaces of the body, looking for evidence of injury, evidence of natural disease, and evidence of medical intervention, and then continuing internally to look at the organs, looking for evidence of natural disease, evidence of injury, and taking specimens as appropriate for potential chemical analysis to help determine the cause and manner of death.
Now, in what circumstances is an autopsy conducted?
Under State Statute 407, any unattended death or any potential trauma, accident, suicide, or homicide, or an undetermined death would be reviewed. If somebody has been in an accident and has been in the hospital for a week, week and a half, they may have done enough documentation that we can tell why they died, and they may not need an autopsy. But in cases of homicide, almost everybody gets an autopsy.
And are you able to provide a rough estimate, I know you don't have the exact number, of how many autopsies you've conducted in your career?
Roughly an average of 250 to 300 a year since I've been practicing.
And that's going back to 1990?
Yes.
All right. I think you mentioned autopsies are a tool to determine the cause and manner of death. Can you just explain to the jury the difference between a cause of death and a manner of death?
A cause of death is a physical disease or a physical injury that causes a person to die. Manners of death are natural, due to natural disease, accident, most often car accidents or drug overdoses or drownings. Suicide, again, that can be drugs, that can be hanging, it can be shooting yourself, other inventive means as people invent, and homicide, deaths due to actions of another, as well as undetermined. Based on the information we have, we can't tell.
Now, when you conduct an autopsy, are they assigned specific case numbers?
Yes, they are.
And as part of your job duties, did you conduct an autopsy in case number ME 2022-909 on a person identified as Adrian Payne?
Yes, I did.
When was that autopsy conducted?
That was conducted May 10th, 2022, beginning at 9:15 in the morning.
Now, was that autopsy documented with photographs?
Yes, it was.
Have you had a chance to review your photographs or the photographs from that autopsy prior to today?
Yes, I have.
Let the record reflect I'm showing opposing counsel with the mark for identification.
You said K?
Yes, Your Honor. Now, as part of the documentation of an autopsy, is there typically a photo of just the deceased's face? It's taken, it's like an identification photo?
Yes. A cleaned up picture of the face straight on for possible use in identification if it's necessary.
You may.
Let the record reflect I'm showing the witness with the mark for identification as state K. And is that the identification photo that was taken in this case?
Yes, it was.
And is that a fair and accurate depiction of the deceased as he appeared in the autopsy?
Yes, it is.
At this time, the state offers into evidence what's been previously marked for identification as state K.
Any objection? No objection. What's been marked as State's Exhibit K for identifications received into evidence without objection as States 11. You may.
Now publishing State Exhibit 11. And is this, as we discussed, the identification photograph taken of Adrian Payne in this case?
Yes, it is.
Now, were there other photos taken during the course of the autopsy showing wounds suffered by Mr. Payne?
Yes, there were.
Let the record reflect I'm showing opposing counsel with the mark for identification as state's composite L.
You may.
The record reflects that I'm showing with a wrong identification and state was not that dental. And you recognize those as photos taken during the autopsy conducted?
Yes, these are a selection of,
And are they fair and accurate?
yes.
At this time, the state offers what's been previously marked for identification as State L and edit.
Any objections?
No objection, Your Honor.
What's been marked as State's Exhibit L for identification without objection from the defense is received into evidence as State's 12.
Mr. Butler?
May.
Give you a laser pointer so you can walk us through these a little bit better. What are we looking at in this photo?
This is a photo of a front-on photo of Mr. Payne. You can see the head, the chest, and the upper arm. And in this particular picture, you can see the nipples are right and left, and he has a defect on his arm and a defect on his chest. And he has some abrasions from resuscitation artifact.
So you circled with your laser pointer in the middle of his chest. So that would not be something from something from attempted resuscitation.
Yes, this would be consistent with doing CPR.
And can you just point out in this photograph of the juror what you believe to be the wounds sustained in this case?
Somewhat in the shadows, but you have 2 wounds on the arm and 1 on the left chest.
Can you describe what we're looking at here?
This is the entrance wound in the arm, the exit wound in the arm, and the re-entry into the chest.
Is this just the same wounds, but now with measurable scale?
Yes, we're measuring it to scale in the chest.
This is again a closer view.
Yes, this is a closer view of the wound through the arm.
What are we looking at here?
In this particular case, when we examined him in standard autopsy position with his hands at his side and his palms up, the wounds do not align, but if you lift the arm and turn it slightly, then the wound through the arm continues into the chest and continues down in through the body.
And this is just a photo with the left hand of the victim.
Yes.
Did you observe anything of note on the left hand?
No. We're looking for contusions, lacerations, chipping of the fingernail.
Is this the right hand?
Yes, this is one of the set of 4 for the right hand.
Did you observe anything of note regarding the right hand?
No.
What are we looking at in this photo?
This is a photograph of the projectile that we recovered from the right abdomen.
So during the autopsy, while you're performing the autopsy, is it correct that you actually withdrew this projectile from the body?
Yes, I did. And we're looking at a sort of cleaned up, this is the top, and you can see that it has gotten into a star shape instead of, so it's a deformed tip, and you can see it has a little bit of a hopper backing. And we have it from different angles, so you can see the deformity of the tip, the core, and then the jacket. In the back, you can see that it's a yellow metal jacket.
just saw of the projectile, did you actually package the projectile up for evidentiary purposes?
Yes, we would package it place it in a small vial and put a label on it from the case, and then I'd seal it and sign the sealing of that.
Would you be able to recognize that from just the packaging, or would you need to open it?
Not from the outside packaging, because then it gets to law enforcement and they put it in multiple manila envelopes and
You may.
Get to a point where you can recognize that.
I can see and recognize what I signed.
So is this in fact the projectile that was removed from Mr. Payne during the autopsy by you?
Yes, it was.
Now, as part of your work conducting autopsies, is it helpful for you to use diagrams? And would that be helpful in describing the autopsy to the jury?
I believe it would.
Let the record reflect I'm showing opposing counsel mark identification as M. Written approach.
Yeah.
Let the record reflect I'm showing the witness with the mark identification as stated in. Are those diagrams done as part of the autopsy in this case?
Yes, they are.
At this time, the state offers its evidence with the previously marked identification as states M.
That's M as in like Mary?
M is in, no.
Okay. Just want to make, all right. What's been marked as State's Exhibit M for identification without objection from the defense is received into evidence as States 13. You may.
What are we looking at here?
This is a diagrammatic representation of what you saw in the photographs, and I used a clear circle for the entrance and solid circle for an exit, and so the wound went from the arm through the arm, misses the humerus, so it just goes through the soft tissue, then it goes into the chest, so that's a circle, and it goes diagonally, it goes through the lung, through the aorta, through the heart, and the other lung, and through the diaphragm, and we recover the projectile, that's the X. Just on between the liver and the side of the abdomen.
You have a second diagram. Can you describe this to the jury?
And in the standardized options that are available for me for the diagram, when you raise the arm, you can see that you can make it in an alignment so that it goes in a straight line through the arm, through the chest, and into the body.
Based on your experience as a medical examiner, with the positioning of the victim's arm based on the trajectory you were able to determine to be consistent, having your hand on a steering wheel?
It could be anything that puts the arm anterior and a little bit above. So it's in a line with the wound through the chest.
Would that also be potentially consistent with having your arm on like a window of a car or window of a driver's side door?
Any position that's going to, any potential scenario that's going to get your arm up and a little bit anterior to the chest.
Now, based on your autopsy, were you able to determine a range of fire?
It appears to be a distant gunshot wound that's more than 2 to 3 feet away because there's no soot, there's no powder tattooing, and there's no gunpowder that's coming out of the end of the gun to cause the explosion, to cause the bullet to go down the gun, comes out in a cloud with the gun, with the bullet. When it gets out of the gun, if you're close enough, it lands on the environment. And it was not on him.
So you're able to tell based on certain things like soot and other things if it's a close range gunshot. Is that fair to say?
That's correct.
But if it's beyond 2 to 3 feet, is that all just sort of the same category?
Yes. Once you get distant, once you have none of that, then it's at least 2 to 3 feet, and exactly how far may be determined by other investigational factors.
Now, as part of an autopsy, is a toxicology or drug screen run?
Yes.
Did the victim in this case have any drugs or alcohol in his system?
No, he did not.
And as part of your autopsy, do you weigh and measure the deceased?
Yes.
What was the weight of the deceased?
He was 247 pounds.
And how tall was he?
He was 80 inches or 6 feet 8 inches.
Now, in your autopsy in this case, were you able to determine a cause of death?
Yes.
What was the cause of death?
A gunshot wound of the arm and chest.
And were you able to determine a manner of death?
The manner of death is homicide.
Thank you. I don't have any further questions.
Ross?
Good afternoon. How you doing, Doc? How you doing today?
Good afternoon.
Very good. Just briefly, you stated that this trajectory of the bullet wound was consistent with an arm being kind of raised in this type of manner?
Raised and a little bit anterior.
Okay. Something like, if I was to try to give you an example, can you see me? Would this be consistent?
Yeah, it's potentially consistent, yes.
Thank you. So could this type of bullet wound be the result of someone attempting to raise their arm up potentially? You know what I'm saying? Someone potentially raising their arm up? Could this type of interior?
If they're raising their arm up as the gun is fired, it potentially could already have the arm up, or it could be in the process of raising it up. And when the bullet goes through the arm, that's...
Thank you. No further questions.
You redirect?
Briefly. So if an arm was raised, as counsel just demonstrated, where would the hand be positioned based on the trajectory you were able to do in the autopsy?
Well, can be a number of potential. All I can tell you is the position of the upper arm relative to the chest. The hand would be out in front. If you don't have, if somebody has their palm up, you could have your palm up, you could have your palm down, you could have your hands. In this particular case, it's a little bit better if it's twisted so that the thumb is down. Twist the arm to get in the in and out hole in the right line.
So obviously, just sort of anatomically, a person, when they have their arm up, they can only extend out this far, right? They can't go backwards at the elbow.
No, you can only go as far as your elbow will go.
So to be in the position that you were able to determine from the autopsy, if the arm was up, it couldn't be going back this way. It would be just facing this way or in this way, as I'm demonstrating.
Yeah, the arm would be in front, because you can't make the hand go back without the arm being in a different position.
Thank you. I don't have any further questions.
All right, may the witness step down?
Yes, sir. Thank you.
All right, thank you. All right, state for your next witness.
Yes, Your Honor. At this time, the state calls Kristen Killinger.
Some sort of firm testimony shall give, shall be the truth, the whole truth, nothing but the truth, so help you God.
All right, go ahead and state your full name for me and spell your first and last name for me.
My name is Kristen Killinger, Kristen, Killinger.
All right, state your main inquiry.
Thank you, Your Honor. Good afternoon.
Hi, good afternoon.
If you could just introduce yourself to the jury.
My name is Kristen Killinger, and I am employed by the Florida Department of Law Enforcement in the Orlando Regional Operations Center.
And what is your position with the Florida Department of Law Enforcement?
I am a crime laboratory analyst in the firearms section.
How long have you held that role?
I have been a crime laboratory analyst for about 5 years.
And have you had any other job titles, or have you had the same job title throughout your time there?
I have been at FDLE for 7 years. I was a forensic technologist in the trace materials section and also in the firearms section, and then I was promoted to crime laboratory analyst.
And in your current role, what are your job duties?
As a crime laboratory analyst, I primarily test firearms to see if they're functional or not. I will also do microscopic comparisons with fired ammunition components, such as bullets and cartridge cases.
If you could just give the jury your educational background to hold the current position you have.
I have a Bachelor's of Science degree in forensic science from the University of Central Florida. I also completed a 2-year training program in firearms identification.
Now, as part of your job with FDLE, do you have to have ongoing training to keep up to date?
Yes, I complete continuing education.
And are you up to date with all of the necessary continuing education to this point?
Yes.
Now, I want to take you back to January of 2023. Were you still employed with FDLE at that time?
Yes, I was a crime laboratory analyst then.
Did you become assigned to be the analyst in this case involving defendant Lawrence Doherty, FDLE case number 2022-0506229?
Yes, I was.
So what were you asked to do in this case?
For this case, I received a firearm and a projectile, and I was asked to compare the projectile to the firearm if possible.
Were you also able to test the firearm to determine if it was functional?
Yes, I also did a functionality test on the firearm.
Can you describe to the jury what a functionality test is?
Yes, so when I receive the firearm, I will kind of look it over, document it, take notes on what I have, such as the make, the model, the caliber, the features that the firearm has. I will examine the firearm to make sure that it's safe for me to test fire. And then when I do feel like it's safe, I will take it onto our laboratory range. And in this case, I test fired it into our water tank, which is just a tank full of water. That way I could recover both the cartridge case and the projectile from the firing process.
And in this case, you yourself actually fired the firearm?
Yes, I did.
And was it functional?
Yes, it was found to be functional.
Now, regarding the projectile that you were sent, what were you tasked to do regarding the projectile?
For the projectile, I was asked to compare it to the firearm if possible to see if the projectile was fired from this firearm.
How was that done?
So I use a comparison microscope, which is just a microscope that has 2 stages, so I can view 2 things at the same time in the same field of view. So in this case, when I opened up the projectile, I documented what I had, and when I felt like I could move forward with a comparison, I took the bullet that I test fired into the water tank, and I compared it using my comparison microscope. I looked at the microscopic imperfections that are present from the firing process, and I compared the bullet that I received as evidence to the test-fired bullet that I fired into the water tank.
Now, these microscopic impressions, are they unique to each individual firearm, for like a fingerprint? Is it unique to an individual?
Yes, the firearm during the manufacturing process, the process of cutting the firearm to make it the shape that it is, there's rifling in the barrel that imparts the spin on the bullet for when it's traveling. To spiral kind of like a football so it travels straight. The process of putting the rifling into the barrel is like cutting metal. And so there's microscopic burrs, and inside of the barrel there's little metal burrs and flakes that are inside that will leave microscopic imperfections on the bullet during the firing process.
Your Honor, permission to approach with what's already in evidence as State 7 and State 8.
Okay. Okay.
Is that you have in front of you the firearm that you were sent to do the analysis on in this case?
Yes, it is.
And is in the manila package, is that the projectile that you did the analysis on?
Yes, it is.
And were you able to make any associations with that firearm and that projectile?
The projectile was identified to the firearm.
Now, when you say identified to, does that mean that that projectile that was removed from the victim in this case was fired by the firearm that you have in front of you?
Yes, it was.
I don't have any further questions.
Cross?
I have no questions for the jury.
All right, may the witness be excused? right, thank you, ma'am. You can step down.
Thank you.
All right, state your next witness.
Your Honor, at this time, the state rests.
All right, ladies and gentlemen, the state has rested its case. There are some legal matters that I need to address outside of your presence, so I'm going to ask you to step into the jury room while I address those, and then when we're ready, we'll bring you back in, okay? All right, have a seat. Any motions or matters that I need to address from anyone or any party as it relates to the state resting its case?
Yes, Your Honor. If I may have a moment, at this time, defense would like to move a judgment of acquittal, and this is the basis for that. As it relates to the charge, it appears that the state has charged my client, Mr. Lawrence Doherty, with a second-degree murder with a firearm. Okay, carries a 25 life minimum mandatory, and as a necessary element, the state is required to prove an element that by an act imminently dangerous to another and evincing a depraved mind regardless of human life, Lawrence Doherty did kill Adrian D'Angelo Payne. And during the commission of said offense, Lawrence Doherty did carry, display, use, threaten to use, or attempt to use a firearm. And Lawrence Doherty actually possessed a firearm with destructive device. Lawrence Doherty actually discharged a firearm with destructive device. And the result of the discharge of the firearm with destructive device, death or great bodily harm was inflicted upon Adrian D'Angelo Payne. And viewing the facts in the light most favorable to the state of Florida, Your Honor, I believe the state has failed to establish by competent and substantial evidence in regards to the necessary element of an act being imminently dangerous to another and demonstrating a depraved mind. The reason why I make this position, Your Honor, is that by definition, just going to the jury instruction, an act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and, not or, and, meaning they have to also establish and is done from ill will or hatred or spite or an evil intent, and, not or, and, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, although it's not necessary for the state to prove the defendant had intent to cause death, the issue in this case is whether as it relates, if you're viewing the facts of this case in the light most favorable to the state, obviously we're raising self-defense, we haven't got to that point, but if you're viewing it in the light most favorable to the state, alternatively, the state would have to still establish, during their case in chief, that Mr. Lawrence Doherty acted with depraved mind, right? And absent, in this situation, the only alternative that would seem to support the facts as we are listed, or as we stand right now, the issue is whether Lawrence Doherty did not have a depraved mind without regard to human life because he acted in the heat of passion based on adequate provocation. That's an issue in this case, Your Honor. So in order to find that he did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was no reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And that Mr. Lawrence Doherty was in fact so provoked and did not cool off before he committed the act that caused the death of Mr. Adrian D'Angelo Payne. And that's what I believe the facts, at best, if we're looking at the facts of this case in the light most favorable to the state of Florida, they have not established a second-degree murder with firearm. At best, in viewing the light most favorable to the state, what we have, because the facts support that this was a heat of passion, if we're viewing it in the light most favorable to the state, right? This is manslaughter. At best. Mr. Doherty didn't have a relationship with Mr. Payne. He only knew of the man's name through his association with his girlfriend over the years. There was no evidence that he had a prior incident with him, any rift, any text, any call, any exchange, any prior situation. All you know, he's coming home and he's surprised by a person he doesn't have any affiliation with, and they have an altercation of words. He's feeling threatened. Well, from our position,
we're saying he's feeling threatened. I know you haven't heard from my client yet, but the evidence still supports that there was an argument. And he went into his home. This is at 1:30 in the morning outside his house. And even by testimony of Ms. Tara Walker, she states that Mr. Doherty asked, why are you here? So what we have here is a spontaneous situation. But he didn't have time to cool off because whatever the exchange was, he immediately resorted to Mr. Doherty having to go back into his home and come back out and ask again, why are you here? While his son is outside, his dad is outside, and they haven't made it safely into the home yet. So at best, Your Honor, this is not second degree, at this phase, this is not even second degree murder with firearm. I would submit to the court. This is overcharged to begin with. Based on that, I believe that element, based on that lack of sufficient establishment of that necessary element, that you must give us a judgment of acquittal as it relates to second degree murder with a firearm.
Okay.
Your Honor, the defendant's actions in this case speak for themselves. He went after someone was not on his property but was parked down the street. He engaged that person in words. He then stormed into his house, armed himself with a firearm. During this time, he didn't, cool off, or he had certainly had time to do that. He then armed himself with a firearm. He came out. You heard the video of Tara Walker screaming for him, "Don't take your gun out. Don't do this, Lawrence." And then he still, after all of that, in that circumstance, aims his firearm at the victim in this case and shoots and kills him. This certainly meets the elements of second-degree murder. It doesn't require an intent to kill, but a depraved mind. Certainly, anytime you point a firearm and discharge it at a person in this circumstance, that shows ill will, hatred, spite, or evil intent. And again, that portion of the depraved mind is or. So it could be an ill will or a hatred or spite or evil intent. And then obviously shooting a firearm at another person is clearly indifferent to human life. So we've met the elements of second-degree murder and ask that you deny the JOA.
Your Honor, may I add something briefly?
Good.
In light, regardless of what the state just mentioned, still sufficient facts that gives you as a fact finder a reasonable understanding of what Mr. Doherty was placed in at that time, that situation. You heard from the expert that the trajectory of how the bullet went through his bicep to go into his chest cavity is consistent and could be because he was raising his hand, arm up. Now the issue is, why was he raising his hand up in the direction of where, if his thumb is down, Your Honor, he could have been holding his thumb like this, or trying to. That's enough right there to not allow second-degree murder with a firearm to proceed, Your Honor, if you're viewing the facts in the light most favorable to the state court.
Wasn't there testimony that from one witness that his arms were up and he was in between the driver's door and the driver or the hood of the car? And that's a fact that is in the light most favorable to state that the arm is already up.
That doesn't negate that his hand is up. He could have had a weapon in his arm, in his hand as well. I understand Your Honor's position. Regardless of the fact there was no rift previous at the time of this situation. This is not something where he intended. I know he doesn't have to intend the outcome of that, but this is literally a heat of passion moment. It can be no other thing. And a heat of the passion killing by law is manslaughter. He didn't have time to cool off. Even the same witness that said Mr. Payne had his hands up also testified that Mr. Doherty was in his house less than a minute. Minute at best. Minute and a half at best. That's not time to cool off when someone's outside your house at 1:30 in the morning threatening you while your child and your father's outside. You just got to finish celebrating Mother's Day. You're on your way home, and unknown to you, someone's lying in wait for you. And when you ask why you're here, you get a threatening posturing response. 6'8", 247 pounds. That's adequate provocation. Thank you.
All right, I'm going to take the matter under advisement. There's one thing that I want to check on, and then I'll be able to rule on that issue, okay?
Thank you.
All right, does the defense wish to present a case?
Yes, Your Honor. The defense would like to call Mr. Lawrence Doherty.
All right, and any other witnesses?
With all candor to the court, I don't believe another witness is necessary. No.
Okay. All right, so a couple of things then, Mr. Doherty. Your attorney has indicated that he's going to call you to testify. You understand that?
Yes, Your Honor.
All right, and he's indicated that he's making the decision not to call any other witnesses other than you for purposes of your case. You understand that? All right, have you discussed that strategy with him? And are you in agreement with that strategy? Okay, So you understand that after you testify, there will be no other witnesses or no other evidence presented on your behalf. Is that correct? All right. Then the jury will have to make its decision based upon the state's evidence and testimony from their witnesses and from your testimony. You understand? Okay. Now, have you had a discussion with your attorney about the pros and cons of testifying? Have you had a discussion with your attorney about the pros and cons of not testifying? Okay. You understand that if you take the witness stand and you testify, that you're going to be treated just as anybody else who takes the witness stand, meaning that the jury is going to get to assess your credibility just like they did everybody else's, and the same rules that apply to their testimony will apply to yours. All right. And you understand that you have an absolute right to remain silent if you want to. Okay. And that if you were to exercise your right to remain silent, I would instruct the jury, as I did during the jury selection, that they are not to consider your decision not to testify against you in any way, shape, or form. You understand that? All right. Do you have any questions about your right to testify or your right to exercise your right to remain silent?
No, but is there a way that I can talk to my lawyer?
Certainly. Go ahead and talk to him, and then I'll follow up. All right, you've had a chance to continue or to consult with your attorney?
Yes, Your Honor.
Do you need any more time to do so with him?
Sir, is there a way I can take a bathroom break before?
Oh, we're going to do that. Don't worry. And so do you have any questions for your attorney or for the court about your right to testify?
No, sir.
Do you have any questions for me or your attorney about your right to remain silent?
No, sir.
All right. And you've indicated to me that you've had the opportunity to discuss the pros and cons of testifying and the pros and cons of exercising your right to remain silent, correct?
Yes, Your Honor.
All right. After having considered those, have you reached a decision in this case as to what you want to do?
Yes, sir.
Okay, can you tell me what decision you've reached?
I want the people to hear my story.
All right, so you want to exercise your right to testify.
Yes, Your Honor.
Has anybody forced you, threatened you, or coerced you in any way to make that decision?
No, sir.
Has anyone promised you anything to make you make that decision?
No, Your Honor.
And are you making that decision because you believe it's in your best interest and you want to? Okay. And is there any other witnesses or any other evidence that you want presented to the jury other than your testimony?
There is one thing that I would like to show.
All right, have you discussed that with your attorney?
It's okay, Your Honor.
All right, so after consulting with your attorney about the issue that you were considering, you're advising me that you no longer wish to have any witnesses or evidence other than yourself testify, is that correct?
Yes, Your Honor.
Okay. All right, then what we will do is take about a 5 or 10 minute recess for everybody to use the restroom and whatnot, then we will come back and start with the defense case, okay? So we'll be in recess. Before we bring the jury in and start with the defense case.
Nothing to say.
Okay, let's go ahead and bring in the jurors. All right, go have a seat. All right, does the defense wish to present a case?
Yes, Your Honor. May it please the court?
All right, you may call your first witness.
I would like to call Mr. Lawrence Doherty.
Mr. Doherty, if you'll make your way over to the witness box for me, please.
Tell me swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
All right, just have a seat. And state your full name and spell your first and your last name for the court report.
My name is Lawrence Doherty.
Spell the first name and the last name.
Lawrence, Lawrence. Last name Doherty, Dority.
Mr. Thompson, you may inquire.
Mr. Doherty, how old are you?
I am 32.
You have any children?
Yes, I have 3.
What are their ages?
13, 8, and 2.
What do you do for a living?
I am a barber.
Have you lived in Orange County all your life?
Yes, sir.
Are you married?
I'm engaged.
I'm sorry?
Engaged.
Let's get right into it. Switch gears a little bit. You obviously been here and sat through this trial so far. You've heard a lot of things. And you actually live in this situation. You recall what happened on May 9th, 2022?
Yes, I do.
Did you explain to the court and the jury what happened?
Well, around 1:30 in the morning, me, my son, and my dad went to my house. My father was taking me and my son home. And as we arrived, I see the car parked at the corner of my home, and I automatically assumed it was Tara. So I thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. And so I walk over there to greet her, to say, hey, why are you parked here? And Mr. Payne gets out of the car. And when he gets out of the car, he's looking down at me. He has his hand in his waistband, and I can see like something silver sticking out on the side of his hip with his hand on it. And I asked him, what are you doing here? And he said, I'm not playing with you, I'll smoke you. I said, what? I threw my hands in the air, and I started freaking out. My dad rolls down the window and asks me, is everything okay? And I told him, I don't know. So I go inside of my home. I retrieve my firearm so I could safely get my son in the house. And so as I return back outside, I see Mr. Payne has moved his car up even more, and he's gotten out of his car again. And so I'm standing in my driveway, and I'm asking him, why are you here? What are you doing here? Why are you here? Can you please leave? Can you please leave? And he's just staring at me.
Okay. How tall are you, Mr. Doherty?
5'8",
How much do you weigh?
145 pounds.
Did you have a relationship with Mr. Payne? Had he ever been to your home before? Did you invite him? I need you to make an audible.
No, sir.
Did you have a relationship with him at all?
No, sir.
Did you invite him to your home? I'm sorry?
No, sir.
Out of all the years that you knew Miss Tara Walker, had you ever actually met Mr. Payne?
Like twice.
Was there any situation where you guys had a issue?
No. I just seen him one time. He showed up to my girlfriend's mother's Thanksgiving or something like that. He showed up unannounced, and I don't even recall the other time.
So getting back to May 9, 2022, when you came, why did you go back in the house? Why did you go in the house?
Because I thought I was gonna die.
Why'd you feel that way, though?
He's outside my house. He's telling me he's gonna smoke me. I have my son outside, I have my father outside. He's there by himself. Nobody, I didn't.
How many shots did you fire? A moment.
I'm trying to go home.
Mr. Doherty, when you speak into the microphone, let's just slow down a little bit. Let's try to take your time and make sure you speak into the microphone, okay?
What was the question?
At some point, you felt you went in the home and obtained your firearm. What were you thinking at that time?
I have to get my son safe. I didn't know. I just thought he was gonna kill me and my son and my father, and I didn't know. I didn't know what was gonna happen.
When you came back outside, you had this firearm. First of all, did you have a concealed weapon permit?
Yes, sir.
So have you taken self-defense classes before?
Yes, sir.
When you came out, did you have any additional words or anything was said by you at that time?
Yes.
What was that, if anything?
I said, "Can you please leave? Why are you here? Can you please leave? What are you here for?"
And what was the response that you got?
He didn't say anything. He was just staring at me.
And at some point, you felt the need to discharge your weapon. How many shots did you take?
One. I saw him. I was saying, "Why are you here? You need to leave. You need to leave. You need to leave. Why are you here?"
How were you saying it? Were you saying it softly, or how did you say it?
Like, "Why are you here? What are you here for?"
Were you talking to him?
I don't know.
Could he hear you?
Yes,
How do you know he could hear you?
because he was staring at me, and it wasn't far. It's like from here to the end of the courtroom. Like, it wasn't far.
When you came out the house, or at the time when you took a shot?
I mean, I was in my driveway the whole time.
Did Mr. Payne appear to reach for something? Or
Yes. When I was saying, "Why are you here? You need to leave. You need to leave. Why are you here?" I seen him going like this, pulling his hand up, like he's raising a gun towards me. And I shot one time, and I called the police, and I put my son in the house.
And before we get to that point, at some point, you stated when you went in the house and came back out that his vehicle was even closer than it was at first when you first encountered him. Is that true? Is that a yes?
Yes, sir.
So after the fire, after you discharged your weapon, you called 911? I need you to speak into the microphone.
Yes, sir.
Did you remain at the scene?
Yes, sir.
Did you cooperate with law enforcement?
Yes, I did.
Did you provide a statement to law enforcement?
Yes, I did.
Even after they gave you Miranda warnings, you gave a statement, right?
I was never read any Miranda rights.
You provided a statement, right?
Yes, I did.
Is there anything else you want the jury to know that you hadn't said?
You know, before I got up here, I thought I knew what to say exactly. You know, but I don't. It's just no.
I don't think I asked you this, but at that time, how old was your father?
60, 62.
How old was your son at that time?
8, 9.
How old? I'm sorry.
8 or 9, 8.
Were you intoxicated?
No. I was with the police for 13 hours.
None of the officers assumed or speculated that you were intoxicated?
No.
Now, at the scene of this incident, Tara Walker was present, right?
Yes, sir. Afterwards.
Did you see her go into the vehicle that Mr. Payne was in?
While I was on the phone with the police, I put my son in the house. I'm on the phone with the police. And I saw my father go over to Mr. Payne to see if everything was okay. And I can hear him telling her, find a piece of plastic so I could try to stop the bleeding. And I see her go through the back seat. She goes to both of the back seats. She goes to the front seat. She goes to the glove compartment, and she just runs. She runs to the other side, and we didn't see Tara until the police arrived.
Do you know, or did you see anyone else that may have had any relationship or affiliation with Tara Walker arriving on the scene?
Yeah, her brother and her father came, and I was just so confused because they had my son and my father and me like chambered away, and she's just frolicking around, calling her friends and calling her family.
Sustain.
And I was just confused.
Mr. Doherty, I'm gonna ask you this question. Did you see a firearm in the hand?
We're here with Mr. Hakeem Robinson, his counsel. Well, you need counsel for the state. All right, we are present now with Mr. Robinson, his counsel, and counsel for the state. I'm advised the jury has reached a verdict. Any reason we can't bring the jury out now and receive the verdict? All right, let's please bring the jury out. Thank you.
Your Honor, the jury is entering the courtroom.
All right, ladies and gentlemen, you may take your seats. And ma'am, juror number 3, are you the foreperson? And has this jury reached a verdict? Yes, we have. Can you please hand the verdict form to the bailiff? All right, the court finds that there are no errors or omissions in the filling out of the verdict form. Madam Clerk, can you please publish the verdict?
In the Circuit of the 4th Judicial Circuit in and for Duval County, Florida, case number 16, 2020, CF 3601B, Division CRE. State of Florida versus Hakeem Robinson, verdict as to count 1. We, the jury, found the defendant guilty of first-degree murder as charged in the indictment. So say we all, done, Jacksonville, Duval County, Florida, signed by the foreperson on July 31st, 2025.
Does counsel for either the state or defense desire the jury to be polled?
Yes, Your Honor.
All right, Madam Clerk, if you can please poll each juror.
Juror 1, is this your true and correct verdict? Juror 2, is this your true and correct verdict? Yes. Juror 3, is this your true and correct verdict? Yes. Juror 4, is this your true and correct verdict? Yes. Juror 5, is this your true and correct verdict? Yes. Juror 6, this your true and correct verdict? Yes. Juror 7, this your true and correct verdict? Juror 8, this your true and correct verdict? Yes. Juror 9, this your true and correct verdict? Juror 10, this your true and correct verdict? Yes. Juror 11, this your true and correct verdict? Juror 12, this your true and correct verdict? Thank you.
All right, ladies and gentlemen, I wish to thank you for your time and your consideration of this case. I also wish to advise you of some very special privileges to be enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in that jury room except by court order. For many centuries, our society has relied upon juries for the consideration of difficult cases. And we have recognized for hundreds of years that a jury's deliberations, their discussions, and their votes should remain their private affair as long as they wish it. Therefore, the law gives you this unique privilege not to speak about the jury's work. Although you are now at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, or from the media, from the attorneys, or elsewhere. So it will be up to you to decide whether to preserve your privacy as a juror. And with the rendering of this verdict, ladies and gentlemen, your service in this courtroom over the past 2 weeks is now concluded. And all of my prior admonitions and prohibitions against looking at the news or reading the newspaper, listening to the radio, or going on social media, or talking to anyone, or looking up anything, all of those prohibitions are now lifted. You are free to do those things if you wish. Keep in mind, folks might want to speak to you, and you are free to speak to them. But again, you are also free to refuse to speak to them. I do want to thank you sincerely for answering your jury summons, coming to the courthouse 2 Mondays ago, and being part of the administration of justice. I say this every week when I have jury trials. Our system of justice, I believe, is the best system of justice in the world, and it wouldn't operate in the manner and method in which it does without citizens such as you who take the time, the consideration, and out your private lives to come down here to be part of our process. So I do sincerely and genuinely thank you. And at this time, ladies and gentlemen, you are now excused and free to go.
All right, the jurors are leaving. Y'all going crazy in the chat, y'all. Ksoo has been found guilty of first-degree murder. So he's looking at a life sentence without the possibility of parole. There was a comment out here, and it went by so fast,
All
but
right,
it was
the
so
jury
important.
has exited the courtroom. All right, that jury has exited the courtroom. Of course, they need to cross over and exit through the other door, but until and before they do come out, counsel, if you will present your client before the bench. All right, Mr. Robinson, based on the verdict of the jury finding you guilty of the offense charged in the indictment in case number 2020 CF 3601, the court does hereby remand you to the custody of the Jacksonville Sheriff's Office, and your bond in this matter shall be Sheriff's Office, and your bond in this matter shall be revoked. Now, he is entitled to a pre-sentence investigation report. Is that sentencing no earlier than 30 days? When would the parties wish to return? I have the week of August. The same week as Mr. Whitaker? Okay. Are you all available to return the week of September 8th? Keep in mind, Monday would be a to-be-set date, and we would set the sentencing on a convenient day that week for all parties involved. Okay. And on the 8th, you all are free to appear via Zoom. That's just a scheduling date. That won't be the sentencing date. We'll pick a date on the 8th. All right, then we'll pass Mr. Robinson's case to September 8 for sentencing to be set. All right, thank you. All right, everyone is excused and free to go.
All right, y'all. So we got the verdict in. Like I said, Ksoo was found guilty of first-degree murder. He's looking at a life sentence without the possibility of parole. Very important message that I put up here, and it was from Kansas J87. Parent your children and take care of them, okay? Because life is precious and the lives of others are precious too. And this is what happens when people or children put themselves in situations, they, playing kid games in a big boy world, to be honest. And now him and Scotty then threw the rest of their little life away. And he was getting ready to take off because from the way y'all showing up in this chat, Ksoo must have been some type of influential person to these, I don't want to call everybody a YN, but to the younger generation, it seems like he had a lot of influence. And so only thing I can tell you is that none of them boys gonna do it for them snitching. And now here's the thing, the evidence is the evidence. And from my perspective, the evidence told the story beyond what Butter and what Blue got up there on the stand and said. I felt like Butter's testimony, I didn't consider it at all. Blue's testimony, I really, didn't want to consider it at all, but you had evidence of them being picked up by Blue, Scotty and Butter being picked up by Blue. You had cell phone data that basically tracked Ksoo back to his Instagram account where he giving out his numbers and all these pin drops. Like there was so much evidence that pointed to guilt outside of the snitching. Now, I ain't by no means telling you that the snitching was cool and it was a great thing that they did it. I'm just saying that don't be single-minded to think that it was just the fact that those individuals got up there on that stand. Look at the evidence. The evidence supported guilt, and that's what the jury came back with. So I just want to thank each and every one of y'all who are rocking out with us. This was actually our last trial that we'll get to stream together. So for all my Taylor Gang members, it's a bittersweet moment. It's an actual bittersweet moment for us. I will still stream tomorrow. Tomorrow's going to be like our last day. So we'll find us something interesting to watch. Maybe we'll do a random docket watch for our last day together. And then it's off to law school for me. So I won't actually get to see y'all for a while. I will still try and keep up with at least the last 3 cases that I want to at least try and follow, which is the Julio Fulio trial. Alicia is going to trial on 8/18. The YNW Melly trial, which I know is set for September the 10th, and then the Tim Harrington trial. So I don't know when. I think they pushed Tim's little Timmy trial day back, but I'm gonna try to keep up with that one too. So again, thank y'all so much for rocking out. If you haven't done so already, hit that like button on your way out and subscribe to our channel because I'll still produce content. We're just graduating. We're upgrading the way our content is going to look and feel. And as I learn the law, maybe I'll be able to apply to a lot of some of these cases and just practice my understanding. Yes, Anita, I think that Tim Harrington's case is supposed to be in October, but I also saw something about them wanting to push his trial back. So he may not start. I'm going to miss y'all too. Thank you. Yes, we actually do have a Discord. I'm glad you brought that up, Beta. We got a Discord. So if any of our Telegram members want to stay in contact, continue to talk about trials, find our meeting place inside of different chats and channels that we all follow, join our Discord. I know, Kim. We got a lot of day ones in the building too. A lot of people that's here from YSL. Like that was one of the first trials. That was the first trial that I started streaming. So it's been a year, y'all. It's been a whole year of us trial watching together. A whole year. Y'all didn't see me go through the LSAT twice that y'all seen me do, even though I did it 3 times. Y'all didn't see me cry. We've laughed, we've shared memories, and I'm bitter. It's so bittersweet, y'all. It's so bittersweet. We became a small family. Our community was always small. But we were very close knit. So all right, I won't get too emotional, but thank y'all so much for rocking out. I hope all y'all have a good evening.